What?
Because its lordship is a urgent matter lordship regarding appointment selection lordship. Division bench directed to consider my appointment lordship, but
Oh.
by virtue of the government advocate's letter lordship, the commissioner secretary rejected the same lordship.
Item 46.
Lordship, Act 2 lordship, I pay lordship.
Item 46 to LCR হয়ে আইছে এটো এলিমেন্টারি সাবলে এটো যদিও মই কাবাক দেখে দিছো সার্টিফিকেট কাবাক এটা নয় বলতো 46
Are you ready, Chisti?
Lordship,
লর্ডশিপ এটো এলিমেন্টারি আইটেম 46
Okay, 2 o'clock.
লর্ডশিপ
May it please your lordship,
Yes.
let the matter be listed for motion, my lord. Earlier, I took time, it is not listed, my lord.
When did you file it?
No, my lord, it was listed, but due to some personal difficulties, I won't be able to argue that on that day. So, next Wednesday, my lord. Hi.
I can't hear you, Mr.
May it please your lordship,
Oh,
with the consent of my sister lordship, I am mentioning item number 38 and 39 lordship. It is a contempt petition in item number 39 lordship, we have to file affidavit lordship.
okay.
And item number 38 is the issue is defined. So my lord may segregated the matters and list after lordship, theory lordship. I have already taken consent from my sister lordship.
I am for the petitioner, your lordship,
Item 38.
and 39.
Your good name, please.
M. Zomanpui. I'll write it down, lordship.
Heart so for the petitioner. On request made by Mr. K. Gogoi. You ready?
Lordship,
Unit counsel
lordship,
appearing for respondent,
respondents lordship.
appearing for the respondent. How much time?
Lordship, in item number 39 after 3 weeks lordship, and 38 segregated lordship, and it will be come after 3 weeks lordship.
After 3 weeks. On request made by the parties. List this matter. This matter is segregated from contempt case 491 of 2019. On its own. Item 39 also same one.
May I please, your lordship, may I prefer listing of this matter for admission ballot on 9th of June. My lord. 9th. Yes, Constitution SMDC matter. Similar petition already dismissed by this honorable court. My lord.
Monday.
School is suffering.
12.
My lord, I beg to mention for listing of the matter, my lord, in admission column, my lord. It was last listed on 24th of 11/2022, my lord. Here are not listed.
14. Apply.
Please, your lordship, my lord, we have filed a miss case on last Friday, my lord. That may be listed on Friday, this Friday, my lord.
Monday.
Then, my lord, Monday will be out of state, and then next 16th, my lord.
16.
May I be your lordship? Lordship, I'm praying for listing this matter, lordship. It was last listed on March 2022, lordship. Lordship, kindly on 8th, lordship. Similar matter has been disposed of, lordship, and I am praying similar order, lordship, on 8th, lordship.
Not on it. Fourteenth.
May I please?
Lordship, I have another prayer, lordship. This is the relation to the school managing committee, lordship. And they are in this case, lordship has issued past lordship interim, lordship. In spite of this interim order, stay order, lordship, they are lordship working, lordship. Lordship, this matter may be listed on lordship 8, lordship.
Yeah.
Obliged.
May I please your lordship? My prayer
May I
is for
please,
listing lordship. For admission lordship, the matter was last listed 31st August 2022. Then after matter was not reached lordship. So currently matter may be taken on Friday lordship.
Okay, right.
Lordship, this matter is about the appointment of assistant professor. It is last came on November 2022. Therefore, it has not been listed, lordship.
Okay.
Admission hearing, lordship.
Next week.
Next date, lordship, on 16.
Yes.
Please.
May I please your lordship? Lordship, I'm praying for listing of an admission matter. It was listed on January, lordship. Any date, lordship,
Yeah, 16.
of last.
May it please your lordship. May it please your lordship.
Yes.
Yeah, beg to mention a matter for orders, your lordship. The matter pertains to unilateral termination of the petitioner. The petition will period as fast money. The lordship, the matter hasn't come up yet.
only for orders. It will not take much of your lordship's time. Any day as per your lordship convenience.
Fourteen.
I'm grateful.
May I please, your lordship? Lordship, I beg to mention one IA, lordship. Lordship, this is for condemnation of delay, 191 days, lordship. Kindly it will listed on in this week, lordship. If it is
Motion.
Motion, orders, lordship. 7, lordship, 7. Much obliged, lordship.
Lordship, I beg to mention a repetition lordship for admission lordship on 12th lordship.
May I please, your lordship, I beg to mention the contempt case 91 of 23, lordship. Any convenient date, lordship, for orders.
16.
Much obliged.
May I please, your lordship, I beg to mention for listing of 2 matters, lordship, one for motion matters and another for admission matters, lordship. Motion matters pertains to suspension
19.
and admission matters pertains to
Both-
termination from
Vote,
service.
vote.
19. 19, lordship. May I please, your lordship? Lordship, I beg to mention for listing of a contempt matter for orders. The matter may come up next week on any convenient date.
14.
14.
May I please, sir, I beg to mention for admission, my lordship. I kindly list the matter 14, my lordship. Earlier matter was like list 22nd of March and left out before this one. Okay.
May please, your lordship, I pray for listing of a matter for admission. Lordship, in this matter, the interim order is to be decided on the basis of an affidavit to be filed by the responding authorities. Lordship, till now, the affidavit has not been filed. So lordship, next week, any day,
15.
15. Lordship, there is under matter which I pray for listing. Lordship, this is relating to BWD candidates. For
16.
much obliged, lordship.
Item 1 of the list, withdrawal.
Yes,
For withdrawal, my lord.
Yes. Now, Mr.
PK Bodle, my lord.
Mr. P.K. Borderland, the counsel for the petitioner. Please for withdrawal. Stop. Mr.
That was my lord.
As does.
As last, then the government.
Standing
council.
Yes, ma'am. Higher education.
Higher education appears on behalf of. Standing council appears on behalf of higher education. Writ petition is dismissed.
Much obliged.
2, motion.
May I please, your lordship, my lord? Hearing this case, mediation.
Appeal has been filed.
Yes, as appeal has been filed, also there is some delay in preferring the appeal, so there is a continuation of delay petition is there. So a notice has been issued in that.
When is it coming up?
Actually, a similar case lordship has been come in other courts also. So other courts has issued the notice of the case and after directed us to obtain instruction regarding the appeal, status of the appeal lordship. So notice may go at this stage lordship.
So far as my knowledge is concerned, my lord, I have not found any appeal in that investigation. Let them punish the.
There won't be
number of
any
the
appeal. Since there's a continuation petition, appeal will not be registered.
Yes, lordship.
Let us see. Heard I alarm, Leonard counsel for the petition. Issue notice. Mr.
M.S.R. Borova for respondent number 3 lordship.
Government advocate. Who appears for elementary? Mr. J. Beku, Leonard. G. Beku, Leonard, standing counsel, elementary education, appears for respondents, 1, 2, 4, 5 and 6. And
I am for respondent.
Borova. Then government advocate appears for respondent number 3. Stop. Respondents are allowed to file after it. This will after 4 weeks.
Three,
Obliged.
Yes,
Instruction, my lord, regarding the submission of application by the mother, my lord. He submitted her application, my lord, in the year 31/7/1999, my lord. When the petitioner was a minor,
when did your husband die?
my lord.
When did the father die?
My
Mother
father
died in
my lord,
1992, my lord.
1992, my lord.
My lord, it is
Then-
31 years. My lord.
Subsequently, her mother, his mother have submitted application, my lord, before the authority for compassionate appointment. That was not considered, and that application is so in respect of OM dated 1983, my lord. There is a no limitation period for 1 year, my lord. And this is a social welfare scheme, my lord. And subsequently, when I have attained the majority, my lord, I have submitted the application.
Please your case.
My father death certificate is page 14, my lord.
Yes.
25/10/1992, my lord. Subsequently, my mother submitted the application that is your lordship found at page 16 onwards. It is a type copy. Last time at page 16, my lord, annexed, and originally is at page 17, my lord, 18th October 1994, my lord.
After 2 years.
2 years. In the 1993, my lord, there is a no limitation. my lord.
Yeah.
Subsequently, the petition format application also submitted, my lord, and that was also forwarded. And I have submitted my application, my lord, on your lordship may found it at page number 30, my lord. On 26/2011, my lord. Page 30, your lordship.
What date is this?
Bottom, the my lord date is written in the page 30, my lord, declaration form part, my lord. Your lordship may found 26/2011.
What happened to your mother's application?
That was not considered, my lord, till date. And by that time, I have attained the majority. My date of birth is 15/8/1989, my lord. And after 21 years, my lord, the age of 21 years, my lord, I have submitted the application, my lord, for compassionate appointment. In case, in fact, my lord, my mother application has not been considered. And that was also rejected by the DLC, my lord.
What is the rejection order?
Your lordship, page 31 is the relevant, my lord, late submission. Twelve 6/2013, my lord, that is late submission, my lord, Rajiv Roy, my lord.
That is correct. Yes, what do you?
And I have also annexed judgment of this honorable court, my lord, is at page 39. Yes. In Khadim Hussein's case, my lord. Para number 2, my lord, that is in respect of attaining majority, my lord. That order was passed on 10/5/2022, my lord. And at para 4, my lord, the said question has been answered by the Supreme Court in a given manner that I have reading from page 41, my lord. The said question has been answered by the Supreme Court in a given manner, but by raising the said question, it cannot be a situation that application is not required to be placed before the DLC if any such questions arises. It would be for the DLC to take a decision on the maintainability with a reasoned order by taking note of the law laid down by the Supreme Court. Accordingly, for instance, this court of directing the district elementary to place the application, that is direction for to place the application before the DLC matter.
This does not cover your case.
Yes, my lord.
Facts and circumstances of this case is different. In your case, it was rejected by the DLC, isn't it?
Yes, my lord, for late submission, my lord. But
In
In
this
other
case, it
motions-
was not placed before the DLC. So this court said, place it before DLC, let the DLC consider the matter and dispose it up by a speaker.
But late submission, that part is 1 year is not a mandatory, it's a directory. From our High Court judgment is there, my lord. It's a directory, my lord.
Your father died in,
My father died in the year 1992, my lord.
25/10/1992. Then you made your application on,
My mother filed submitted application on 18/10/1994, my lord. Thereafter, I have submitted my application, my lord, on 26/2011.
that is after how many years?
That there is a delay, my lord, due to my minority, my lord. And in Mrs. Noyanmani Das case, my lord, this honorable court also held that that period of 1 year is not a mandatory, but it's a directory, my lord. That judgment I have, my lord, reported in 2018.
Maybe it is directly, but the delay, have you explained the delay? Just
But my-
because you have to wait for your majority, that does not mean, how will you?
My
spend
mother's
all this?
application has not been considered, my lord. Subsequently, I have applied.
When was the
If they
first,
have considered my mother's application, my lord, in that case, I have no chance, my lord. But they have failed to consider my mother's application. On that count, last occasion, your lordship directed them to obtain instruction whether my mother's application is considered or not, my lord.
at this stage, I don't think we can have a consultation of it.
Let them file their affidavit, my lord, in that case.
Why should they file the affidavit? There's no point in filing the affidavit. Facts describes everything.
But in respect of 1 year,
How long is the delay?
Delay 31 years.
31 years. Of the present petitioner.
Present petition.
Then
on
And-
26/3/2000, that is also they have considered, my lord, in 23 also. On that consideration, they have also stated that I have applied in 19/9/1/2014, but I have applied in 2011, my lord. 26/2011, and they have simply rejected my case, my lord, at case 52, my lord. Your lordship
no,
found that.
it says late submission.
And against this, I have also submitted another order from this honorable court as page 44, my lord. Here in this lordship, you may found at para 5, my lord. Page 46, your lordship may found.
Yes.
The provision of avoiding late submission of application is on the principle that if the family could survive for a particular period of time, there is also a corresponding presumption that the family does not need any further compassionate appointment. The said principle is correct if it is looked from particular point of view. But again, further question would remain as to in what manner the family survived for intervening periods in the circumstance where no competent person was available for seeking compassionate appointment for the intervening period. That there is a interpretation from this honorable court also, my lord.
My lord. The first submission is mother is not before us, my lord.
Yeah.
And if at all her application was rejected, she could have come within time, my lord, approach this court. And this present petitioner, when his father was died, he was only 3 years old, my lord. As per page 30, my lord, his application. And at that time, their family getting pension, my lord. And if after 31 years, the compassionate appointment, the scheme of compassionate appointment is considered by this court, then whole scheme will be vitiated.
It's a compassionate opinion, my lord, is to give, my lord, to tide over the present crisis, my lord, to the plenary family, man. And it is, they are getting pension and also they survived 31 years, my lord. So
This is, it's a welfare scheme, my
and
lord.
my
I
lord,
paid,
there
my
is
lord,
judgment from
by the
Honorable
government, my
Apex
lord,
Court
for
Sanjay
their
Kumar.
employees, my lord. And the last part of the order, my lord, that order in page 46, your lordship, map. From such point of view, we demand the matter back to the DLC, director required to DLC to make. Page 46, I am reading, my lord.
I've read
Para-
that. I've
Para
read it.
6,
I've read
inquiry as to what manner and under what circumstances the family of the petitioner had survived intervening period, and whether such survival can still be considered to be a state of adverse financial situation, or facts of the present case shows that family of the petitioner survived on a acceptable financial condition. There is the view of this honorable court, my lord. I am not on 20 years or 30 years, my lord, but I am only on that issue, my lord, that my application may be considered, my lord.
That was considered. It was
That was
rejected.
considered only on the wrong ground, my lord. Since from our high court, there are several judgments, my lord, regarding the minority issues, my lord. And at the time of death of my father, my lord, I was only 3 years old, my lord. That is an admitted fact, my lord.
Yes. We'll dispose it. Heard I alum, then counsel for the petitioner. Also heard who appears for elementary. G. Bekul, then the standing counsel. Elementary education appears for respondents.
5, 6,
Respondents 1, 2, 5, 6, and 7. And Mr.
G.
Bhopal, then the governor for the respond number 3. 3. Stop. Para. The father of the petitioner. While serving as assistant teacher of Umarpur ME School under block elementary education officer, Badarpur block of Karimganj. Died in harness on 25/11/1992. Leaving behind the petitioner and his mother, another family member. Thereafter, the wife of the said deceased, the wife of late Matilal Rai, made an application for appointment on competition grounds on. Where is your application, mother's application?
My mother application submitted on 18/10/1994, my lord.
Page. Or made an application on 18/10/1994 for appointment on competition grounds. The case of the murder was not considered. However, the mother kept silent. His mother, the petitioner's mother kept silent. And after the petitioner had attained the age of majority, he made his application for appointment on compassionate grounds on 26/2011. The case of the petitioner was considered by the concerned district level committee on 12/6/2013. And his case was rejected for late submission. So, being agreed, petitioners before this court. For a consideration of the materials available on record would clearly indicate that after the death of the petitioner's father, his mother made her application for appointment on conditional grounds, which was not considered on conditional grounds on 18/10/1994. Stop. However, the same was not considered by the respondents and stop. How further, murder of the petitioner did not agitate at any point of time. Stop. Thereafter, the petitioner on attaining the age of majority, i.e. 21 years, writes his application on 26. 2011. There is already a delay of how many years?
31 years.
31 years.
31 years in making the application of the petition. Stop. No reason. Have you given any reasons for the delay?
In my petition, my lord.
Yes.
Yes, my lord, I have stated in. Para 8, my lord. Para 8, 9, and 10, my lord.
The reason given for the delay in making the application for appointment on conditional grounds by the petitioner is that when his father died, he was a minor, aged about 3 years old. And therefore, after he attained his majority, he submitted his application on 26, 2010. On the consideration of the materials available on the form, I see no reason to allow this writ petition. Inasmuch as there is already a delay of more than 31 years. And it appears that the petitioner is making this application only as a source of getting an employment after attaining his majority. Stop. Accordingly, there's no merit in the writ petition, and the same is accordingly dismissed.
In fact, it's not 31 years, but it's 19 years, my lord. Since my lord, 1992, my father died. I have applied in the in the year 2011, my lord. So the delay is 8 plus my lord 11. That is 19 years, my lord.
19
Not
years.
31.
19 years. Changed to 31.
Oblige, my lord.
Or
Good.
Yes. Yes, please.
Lordship, government is directed to file or to obtain instruction. Lordship.
Yeah, Gogoi, you have got your answer.
My lord, may issue formal notice in this case.
Why should we issue notice on this?
Otherwise, lordship petition is not maintainable. Lordship.
It's premature.
Even also, lordship.
Have you challenged the advertisement?
Lordship, actually, my senior is not well. Lordship.
Who's your senior?
SKN Mohammed. He is claiming for regulation. He is not challenging the advertisement. Lordship. Even regulation is not permitted under the rule.
He appeared in the selection process. He apprehends that he will not be selected. That's all. isn't
Lordship.
it? Then How can we maintain this with petitions?
Lordship. Action for the lordship.
Okay, let us adjourn since his senior is not there.
Lordship.
On request made on behalf of SN Mohammed, let the petitioner. List the matter after 2 weeks. Mr. K. Google and the standing council. Appears on behalf of the higher education.
5. Lordship.
May I please have it, sir? The matter relates to appointment on compassionate ground, my lord. So the petitioner submitted application, my lord, on 19/5/2017, my lord. My lord, though it was filed on 2017, my lord, they have not responded till that, my lord. They have been assuring that, my lord, something will be done, my lord, but nothing has been done till that, my lord.
Baro,
Lordship,
As per Faizul Nasser case, my lord.
after 6 years, he has
Since
filed the application, Lordship. It has to be filed within 1 year, Lordship.
at least has it been considered? At least you should consider the matter.
My lord.
At least consider the matter, and if you have to reject or allow,
Yes,
you
ma'am.
do it.
That is philosophy.
You take some instructions whether his case has been considered or not.
Lordship. I'll take the
Third,
instruction.
Mr.
D. Bhuya, my lord.
D. Boya, learned counsel for petitioner. Mr. Esa Barrow, learned government ethics, shall take instructions as to whether the case of the petitioner for appointment on compassionate grounds has been considered by the concerned DLC. How much time will require?
2 weeks, Lordship.
List the matter after 2 weeks.
Highly obliged, your lord.
6.
Yes.
Hello, matter pertains to my regulation, my lord. My lord, similar case has been pending before this honorable court, my lord. WPC 5824 of 2019, my lord, leading case, my lord. So I pray for notice may be issued, my lord. This matter also take with this, my lord.
When is this, when are the other matters coming up?
Hello. Not my lord, I have to check, my lord. But I have the number, my lord, 5824 2019, my lord, leading case, my lord.
2019,
my lord. Notice may be issued, my lord. I'll take this matter, my lord.
yes.
Lordship, at least this notice may go, Lordship.
Third, Mr.
D. Gogoi, my lord.
D. Gogol, let me consider. If you notice. You are applying for Mr.
SSA, Lordship.
Standing counsel.
For 6 and 7, yes, Lordship.
I am for 1, 2, and 3, lordship.
Mr. K. Gogol, Learned Standing Council, Higher Education,
Lordship, CGC, lordship.
or Learned CGC. Appears for respondents, 1, 2, and
3, lordship.
3. And Mr.
B. Chaudhary.
P. Dowdy, Learned. You are appearing for
4 and 5. 4, 5.
I am appearing for 6 and 7, Lordship.
Government Advocate,
Mission Director Standing Council.
Standing
SSA.
Council. SSA appears for respondents, 6 and 7. Elementary, who's appearing? Mr. J.
4 and 5, my lord.
Standing Council, Elementary Education, appears for respondents. Notice on respondents are complete. However, it's going to extra copies. Respondents are. List this matter after 4 weeks, along with WC 5824 of 2018.
Lordship, let's take my lord. Take this matter, my lord.
Yes.
Highly obliged.
5824, isn't it?
Yes, my lord. Public 19, my lord. Highly obliged.
7.
May I please?
Yes, please.
My lord, this matter regarding compassionate appointment, my lord. Petitioner's father was, my lord, the assistant teacher, my lord, at Bokria or MB School, Hailakandi, my lord. And he died on 10/8/2007, my lord. And my lord, then he applied, my lord, 18/8/2007, my lord. Lordship, kindly have a look, my lord. I beg to, my lord, refer, my lord, page my lord, 24, my lord. Page 24, my lord, lastly, his name is there, my lord. Last, my lord, after 31, my lord, this is 32, my lord. This is before your lordship, my lord, Masuk Ahmed Borbuya, my lord. He was rejected, my lord, on, my lord, 30/11/2012, my lord. Less qualified, that is HSLC passed, my lord. But, my lord, it was not
Where's your application?
my lord, his application date, my lord, lordship, I beg to refer from their order, my lord, page 48, my lord, last rejection order, my lord.
Last rejection.
Yes, my lord.
You were rejected for.
Yes, my lord. I challenged, my lord, last rejection, then they apprised us, my lord. Earlier, I was also rejected, my lord. Page 48, my lord, their last rejection. This is on, my lord, 5/10/2021, and it was communicated, my lord, by the Deputy Commissioner on, my lord, 11/10/2021, my lord. Page 48, Annexure 9, whereas the application for compassionate appointment in Elementary Education Department, Hailakandi, was submitted by Masuk Ahmed Borbuya dated 18/8/2007, is received against the post deceased employee late Safikul Haq Borbuya of the department on service, who is in father of the applicant. Now, my lord, reason of the rejection is the last paragraph, my lord. Whereas the after thorough scrutiny of the application submitted, it was observed that the next of kin certificate not submitted along with the application, and in accordance with the office memorandum number so and so, dated so and so, resolved that the application of Masuk Ahmed Borbuya, which is not
Lordship,
yet for
Please, 48,
recommendation to the state
rejection order.
SLC
the
for
DLC
compassionate-
meeting was held on 5/10/2021. So it was rejected on the ground that he was not having the next of kin certificate, Lordship. Lordship, may kindly see the date of the DLC meeting 5/10/2021. Now, Lordship, may come to page 18, Lordship.
Page
18, 18. The next of kin certificate, page 18.
The first one is, my lord,
Lordship,
page
I'm submitting.
16. Page 15, my lord,
Page
first
18,
one.
Lordship. Page 18, Lordship.
It was
The
subsequently, my
date
lord.
14/12/21. That means it has been procured after the DLC
No, my
Milos
lord,
meeting, Lordship.
kindly I may be allowed to place. Kindly I may be allowed to place. This is my.
Yes,
Yes. My lord, page, my lord, 15, my lord, my first next of kin, my lord. Annexure 1, my lord. And it was issued, my lord, on 26, my lord, originally is, my lord, page 16, my lord. 26/11/2007, my lord. And, my lord, due to some, my lord, reason, my lord, it was lost. Then it was, my lord, second one is issued, my lord, on, my lord, 14/12. This is duplicate one, my lord, 14/12/2021, my lord. But, my lord, in my first particulars, they prepared, my lord, lordship, kindly have a look. My learned friend may also appreciate, my lord. Page 20, my lord, their first particulars which they prepared, and it was very much, my lord, marked as yes, which signifies that, my lord, next of kin is there. Page 20, Annexure 4, my lord, serial number, item serial number, my lord, 8. Next of kin, my lord, yes, my lord. Serial number 8, my lord, page 20, my lord, in the middle, it is given, my lord, item was 1, 2, 3, 4, 5, 6, 7, 8, my lord, and my item number 8 is, my lord, next of kin is my certificate. Yes, why, my lord, which means yes, my lord. Therefore, my lord, they in the year, my lord, 2012, when they rejected my claim, my lord, it was ground that, my lord, I have quoted this rejection, my lord, page, my lord, 23, my lord, Annexure 5. They, my lord, said that, my lord, my qualification is HSLC, therefore I am less qualified. But this was not communicated, my lord. I was communicated, this is the last rejection before your lordship, I placed, my lord, page 48, my lord. And 48, I have challenged, my lord. And during the, my lord, this pending writ petition, my lord, they apprised, my lord. Lordship, kindly be look, I have annexed this order also. Relevant portion, my lord, page 49, my lord. I challenge, my lord, last rejection, page 49, my lord. And they apprised us, my lord, page 50, that, my lord, his candidature was earlier also rejected, my lord, on 30/11/2012, my lord. Then I immediately withdrew this writ petition, my lord, and filed this new one. And my lord, your lordship, exactly same matter, your lordship passed similar order. Lordship, kindly I beg to refer, my lord, my first page 24, lordship, kindly have a look. Kindly, my lord, I am going back, my lord. Page, lordship, here, my lord, serial number, my lord, 6, Tahera Begum Loskar. She was also, my lord, rejected due to, my lord, lack less qualification, my lord. And she was again, my lord, like the present petitioner, exactly she was also, my lord, rejected in the year 2021 in the same sitting on 5/10/2021, my lord. Therefore, she filed, my lord, writ petition challenging both the resolutions, my lord. And your lordship was pleased to pass the order, my lord. This is page 60, my lord.
Yes.
Relevant portion, my lord, page 61, my lord. I beg to, my lord, read out this order, my lord. This is small order, my lord. Paragraph 61, paragraph 2, my lord. The father of the petitioner, while serving as assistant teacher in Bowergat LP school, died in harness on 14/12/2011. Thereafter, the petitioner made an application on 5/3/2012 for being appointed on compassionate ground for the post of assistant teacher in LP school. The case of the petitioner was not considered by the district level committee, and therefore she filed WPC number so and so before this court. This writ petition was disposed of by order dated so and so, directing the authorities to place the application on the petitioner before the district level committee and to consider the same in terms of the criteria laid down in Achyut Ranjan Das versus State of Assam, reported in so and so, and in the Malad Fajirunisa versus State of Assam, reported in so and so. Therefore, that the district level committee in its meeting dated 30/11/2012 rejected the case of the petitioner on the ground that the petitioner had no requisite qualification to be appointed to the post of assistant teacher. The petitioner approached the concerned respondent for consideration of her case, and accordingly her case was placed before the district level committee Hailakandi, which held its meeting on 5/10/2021 and again rejected the case of the petitioner on the ground. Yes, yes, ma'am. So, my lord, at first, my lord, rejected, my lord, I am less qualified, my lord, which was not communicated, my lord. In good faith, my lord, I was pursuing the, my lord, case, my lord, before the department. Then, my lord, in the year 2010, my lord, 21, my lord, they rejected, my lord, that I did not submitted, my lord, next of kin certificate, my lord, which is, my lord, contradicted itself. That apart, my lord, in the first particulars itself, my lord, it is noted that, my lord, I submitted, my lord, my next of kin certificate. Nevertheless, my lord, presently, my lord, I have all the certificate, etc. before the lordship submitted, my lord. So, considering, my lord, day after tomorrow, my lord, they are holding that DLC, Hailakandi, my lord. Can be case may be considered, my lord.
Yes.
Lordship, first, that case 48, the DLC meeting, Lordship, of 5/10/2021. Petitioner has challenged that DLC meeting by writ petition number 434/2022.
Page.
Then Lordship may kindly come to page 52, the order, Lordship.
Yes.
What happened, Lordship, in that round of litigation, we have produced the original record, and after we have filed a detailed affidavit, and after filing our affidavit, Lordship may kindly see, on instruction of the petitioner Masuk Ahmed Burma Council, namely Mr. SB Loskar, pays for withdrawal of this writ petition with liberty to file afresh as and when a new cause of action arises. New cause of action arises, Lordship. Thereafter, Lordship, Lordship may kindly come to page 54. Another order. He has filed a writ petition 7813/2022. When that issue was raised, That because earlier the liberty was given to file afresh only because when a new cause of action arises, Lordship. Here, kindly, Lordship, see, on after some deliberation, Mr. A.M. Barbhia praised that he would like to withdraw the writ petition to file a review petition against the order dated 17/11/2022 passed in WPC 43/2022. Now he has come challenging this.
And it is
Can you see
reviewed,
the
it
idea,
is reviewed, already reviewed, my lord, has not read out, my lord, page 55, my lord. Already it is reviewed, my lord, and as and when it is omitted, my lord. Paragraph, my lord, page 58, paragraph 11, my lord. Paragraph 11, my lord, after hearing the Planet Council for the parties and considering the entire aspect of the matter, the observation made in the order dated 17/11/2021 passed in the connected WPC number so and so, that is as and when a new cause of action arises as available in the last part of the second paragraph of the said order dated so and so be deleted from the said order passed in the connected writ petition number so and so, and which shall not be a part of the said order any further.
Yes,
My lord.
That has been reviewed, Borough.
Lordship. Now, Lordship, two DLC minus are there. So that recent DLC minus is binding, Lordship. And Lordship may kindly see page
Where
18.
is this minus 5/10/2021?
Only the order is here, Lordship.
Page 48, my lord, this is
48
communicated
is the
to us,
order.
my lord. With the, my lord,
Page 8.
Where's the minutes?
page 48, my lord.
Get
We
a
have to
copy
get
of-
it,
Get a
Lordship.
copy of the minutes.
Lordship.
Third AM, Borough, and then-
My lord, day after tomorrow, my lord, meeting, my lord, after 2 years, my lord, they are holding the meeting, my lord.
Just you have to wait now. AM Borough and then council for the petition. Mr. S. Borough, then the governor. Shall produce a meeting of the minutes of the DLC. Hailakanda. Held on 5/10/2021. Can you do it by tomorrow?
Tomorrow. I'll try, Lordship.
This matter again on tomorrow's what date? 6th. 6th.
Deep reply.
Try, you can try.
My pleasure, Lordship. My lord, under the college provincialization rules, LDA, now known as junior assistant, can become a senior assistant after 5 years. And then thereafter head assistant after 2 years. My lord, over here, I got the first opportunity after 30 years. From LDA, I became a senior assistant, that is UDA. My lord, the crux of the matter over here is that DPC set in the year 2020 and recommendation was forwarded for necessary approval on 24/6/2020. My lord, that is an important date, my lord.
24/6.
24/6/2020. That was sent before the director hire. And my lord, under the rule, the director has to pass. Under the rule 7B, director has to communicate the order within 30 days. Accepting or rejecting, whatever it is. But he has kept the file for 19 months. And as a result, what happened, my lord? My next chance to get the appointment to the post of head assistant, which I am holding as an in charge as on date, that can't be fulfilled, my lord. My only grievance, my lord, why the director has kept it for 19 months. If that effect is given, suppose we take that 1 month, ultimately it did not reject. If we give, if it as per rule, considering the rule 1 month, and if we take the date, that will be 24/7/2020, after 30 days. And if that is the date of effect given, then my lord, as on date today, I'm eligible for that post, which I'm holding as in charge. Otherwise, my lord, my service career will end. I'll not I'll never get the chance to hold that post. Because I'm going to retire next year, March, and from the January, I'll become eligible. And it is not possible, my lord, within 3 months, they will sit for the DPC, then recommendation accepted by the GB, then forwarding before the DHE, and then DHE will pass the order. I don't expect that, because earlier occasion when from junior assistant to senior assistant, it took 2 years to sit the DPC. Post was fallen vacant in 2018. They sat in 2020. I don't know why the director has kept the matter, and ultimately I was given the promotion, my lord, 22, my lord. That is after 19 months, he has kept the file with him, my lord. So if my lord looks at the 7B1s,
Which rule?
my lord, this is a college provincialization rules 2010. It is page 496. My lord, if my lord is holding this book, then it is 496.
Yes.
My lord got.
Yeah.
My lord, rule 7, page 498. My lord, 7, direct recruitment is A, either direct or promotion, and then recommendation of the selection committee. B, my lord, the director shall communicate his orders within 30 days.
What's the recommendation?
Recommendation, my lord. My lord, recommendation is on 24/6/2020. That is page 31 and 31A, my lord. That is the proposal, my lord. My lord, page 29 is the DPC, your lordship can see, my lord.
Page.
My lord, page 33, your lordship may see. My lord, almost after 2 years. This is the order of my promotion to the post of senior assistant. Over there, my lord, it is written as per recommendation. In the 5th line, 4th line, governing body is resolution number 3 dated 3/6, adopted by the governing body of Guwahati College so and so, so and so. And my lord, last, it is the effect is from the date of joining, that is on 17/2/2022. If that is the scene, my lord, over there, one thing is there, suppose I join in the month of December also, they take it as on 1 year. So it will be 2012 and 2022 and 2023. On 24 March, I'm going. So though I'm holding the post as on date, the top post, that is the head assistant on in charge basis, that is the last order, my lord. Page 36. You are hereby appointed as head assistant of the college with effect from so and so until further order. But as per rule, I get the promotion only when the DPC recommends and the order is passed by the DHE on acceptance of recommendation of the DPC by the governing body. So my tenure ends. I superannuate in the month of next year, month of March. I become eligible in the first of January. So within these 3 months, my lord, I don't expect that my promotion will be made. But what if they give me the effect after 1 month, as your lordship has seen 7B? My lord, the director has to reject or accept. It is not that he rejected. As my lord is seen the order of promotion, though it is after 19 months, he has given me he accepted that. So why didn't he accept that 1 month? Another thing, if you could have said from the date of recommendation or after 1 month, his period, keeping his period aside, that my promotion is given but with effect from 24/7/2020, then also I would have been eligible as on day today for that post, my lord, the last post,
Which post is that?
head assistant.
That is-
Yes, my lord.
No, you are promoted as head assistant. is-
No, it's not it's in charge basis. I've been allowed to officiate. That is the last order. I don't get anything for this. It's only the last part of my service career. Another 9 months I have got. With that, my lord, promotion, I'll get only some kind of a benefit towards my pensionary benefits, nothing else.
Oh, you are appointed as head assistant in charge.
In charge.
So you want to be a regular head?
Yes, my lord, I deserve to be regular. Suppose that
Yes,
1 month.
This notice may go affidavit will be required in this.
Yes.
Without affidavit, it's difficult.
Let them file an affidavit, but don't take a long time.
No, we'll file lots.
Petitioner is retiring when?
My lord, I'll retire next year, March.
But Mr.
And lots of work. My lord, only one thing I will point out. If my lord allows, if they agree, so they just can't give me automatic promotion. The DPC has to be there. It has to go as per the rules, my lord, of 2010. DPC has to sit. Then it has to be accepted by the GB. GB has to forward before the DHE. DHE has to consider again that within 1 month. So only thing, my lord, within 4 weeks, if the a small thing.
But Mr. J. Then the council of the petition. Issue notice.
Eh, Small 1 and 6.
A.R. Davinder, then standing council,
Higher education. That's
higher education, appeals for respondents, 1 and 2.
1 and 2.
Stop. The petitioner takes steps for service of notice on respond number 3.
By post as well as Dasti, my
By
lord, because
registered post 80 within 1 week, 1 week from today. Additionally, petitioner is also permitted to take Dusty service on the respond number 3 to the registry of this court within a period of 1 week. Thereafter, petitioner shall file an affidavit to that effect. Stop. The respondents are allowed to file counter affidavit, list the matter after 4 weeks.
my lord, there is a representation. There will be a not. There should not be any bar
Who
to
is it?
their page 35.
Pendency of district petition shall not be a bar on the respondents,
That's one number 2.
on the respond number 2. To consider the case of the, to consider a representation dated 1/2/2023 made by the petition.
Deeply obliged.
Aye.
May I please, Your Lordship? Lordship, I am serving as a school teacher, Lordship. Lordship, pursuant to an advertisement issued by APSC, Lordship, page 29, Lordship.
My lord, before my learned friends start lawsuits, here lawsuits, in this case lawsuit in the policy is shown as higher education lawsuit, but the matter relates to secondary education, and they have served the copy only just few times back lawsuit.
Lordship, that is there,
So
Lordship.
I couldn't go through
Lordship,
the.
just now I gave him a copy, Lordship. I saw the error in the cause list only now, Lordship. It should be corrected in the cause list.
So
Okay.
Chisti, what you want? You want something?
No, lawsuit, APC is the main.
Lordship, APSC needs to bring the Lordship, because they are delaying in the process, Lordship. That is my grievance, Lordship.
Proceed.
Lordship,
All right, I'll take instruction, madam.
You want to take this?
Lordship.
But M. Bhagwati, then the council for the Bhagwati, then the council. Mr. T.J. Manda, then the senior council.
For respondent 3 and
And
4.
also standing council, appeals. Press for how much time?
Within either 12 or 14, madam.
Press for which time? Press a lot. This the matter on 14th of June.
Lordship, for respond number 2, I may be allowed to make it secondary, Lordship. Director secondary education, Lordship.
You've typed it.
Respond of page 5, Lordship. Director, Department of School Education, it should be secondary. That is Mr. Sisti's grievance, Lordship.
It should have been director of secondary education lawsuit, not Department of School Education. That first title is wrong. So
Lordship.
raising with director.
Now, nowadays it is a bit confusing, Lordship. They have changed the nomenclature, Lordship. So I will maybe allowed to correct it, Lordship. By hand.
Yeah. You
Lordship. Much obliged.
And registering with the director, so our name is a cost-based lawsuit. Secondary.
Secondary education.
Registry is also directed to reflect the name of standing council. Secondary education
Secondary.
in the cost list instead of higher education.
Yes, obliged.
Much obliged.
Then.
Yeah, here's the petitioner is working as an assistant professor, Bodo language in a particular college. After due following procedure of law, advertisement, etc. He was appointed Annex 3, page 15. Since 2009, he has been working in a non-sanctioned post. Page 15. Annex 3.
Yes.
Now, since this is a non-sanctioned course, that's why Annexer 6, page 18, in persons to the director requisition, the principal of the college issued the forwarding letter, your lordship, subject information regarding proposal of creation of post of assistant professor in Department of Bodo, with reference to the earlier director order 4th November and later is 11th November. My lord, this whatever the proposal as the particulars are sought for, my lord, issued by the principal, my lord, followed by page 19, the academic year and the, my lord, the student enrollment number along with the name of the petition has been sent. Nirmal Singh Bodo, my lord, since working 2009. Followed by page 20, these are the academic, the student ratio has been only the single Bodo teacher. Now I take a look at page 17, page 21, Annex 7. This is the government letter by which in serial number 2, Pragjyotish College, one post was created. The post which was in which this petitioner was working. Now page 22, Annex 8. This is the communication, persons to this government order, director issued the principal, serial number 2, Pragjyotish College. May I read, reference government letter number dated such and such, we just I referred, Annex 7. With reference to the such a subject, I would like to inform here with the connection with the 11 number of assistant professor in Bodo language in a such and such college under such and such. So the post was sanctioned. Now, suddenly, while I was working, the advertisement was issued for filling that post, which was working since 2009. This was published in the Sentinel, 13 November 2022. Now, as on date today, no interview was held. I have also applied, Now, my apprehension is, I have filed an Annexer 10, page 24, praying for regularization of that post, which I was working since 2009. I have all the requisite qualification, UGC norm, net qualified, set qualified. So I made a representation, page 24, Annexer 10. Though the post was applied in the year November 2022, as noted, no further process initiation of the interview, calling letter, etc. was not yet done. At this stage, may I pray, let the representation may be disposed of, and consider, my case, since I am going to be cross, though I have applied at that time as a age bar, now I have already, as on today, I have crossed. So that representation may be taken into consideration, considering my.
See, here you have an advertisement.
Fine.
You make your application against the advertisement.
My lord, I have made it.
You appear in the exam.
No,
Not yet.
not yet, completed. That is why.
So they will make the, you're willing to participate in the examination.
No, my lord, problem is in the interview, my lord, my last experience will not be considered, my lord. So, my lord, maybe, my lord, is a case, my lord, in the marks qualification, my lord, some other candidate may come. That's why I have highly representation, my lord. Let my past experience also
See, the
considered.
issue is this. There's an open advertisement
Yes,
advertising your post.
my lord,
All right.
my lord,
People have applied for that post.
my lord.
Now, how can this court give a direction to consider your representation for regularization to that post which is already advertised?
My lord, that is true.
How do you give an order?
My lord, that in a representation, my lord, I pray for my regulation of that.
How?
My lord, there is a,
When the post is already advertised
Yeah.
and all from the candidates from open market have met the application.
submitted, my lord. That is true.
How can this court pass an order asking you, asking the respondents to
I am-
consider a case for
My lord,
regularization?
I have told by the petitioner, my lord, you all kindly appreciate November 2022, they are in some speculation, my lord, to consider that aspect, that my lord, I am told by this petitioner, my lord. That's why your lordship kindly appreciate November 22 advertisement was issued and we are in June 23, yet not process was completed. Even calling letter was not issued. So that is why I am told by the petitioner, my lord, they are in a speculation, my lord, to consider thinking in.
Then let them do the
That's why I made at this state limited prayer.
one
Let
order,
the,
one order this court passes that
Well,
consider representation.
Mala, that's why I'm paying.
Then the rest of the other candidates will
Lordship.
start coming to court.
Lordship.
Mala, that is true, my lord.
They will say, the post which we have applied for is already regularized from the back door.
My lord,
That's all.
I am
Lordship.
praying
So
for my
basically,
taking
it's a
of this,
back door appointment.
my lord, taking of this note, my lord, that my representation may be taken into consideration at least, my lord.
No, I can't pass that.
My lord, in the, your lordship kindly appreciate the past experience which I have been working, my lord,
That
since
we
last
understand,
more
but
than 20,
if
13
you have
years.
come before the advertisement was made,
That is.
if you have come before the advertisement was made, this court could have passed the
My
order.
lord, that is true.
Once advertisement is made and candidates have made the application, how can I pass an order today?
That is, I understand. my lord.
So it's up to you. You want to withdraw this or dismiss it?
Well, your lordship, wisdom, please.
Hmm?
Your lordship, wisdom, please. Let that order me ask. Well,
Yes.
only prayer, well, actually, what I'm, well, your lordship, absolutely correct. Actually, in fact, I told the petitioner, yes, he could have come earlier challenging that.
See,
Well,
one thing
since-
is this, if I dismiss this writ petition, remember there's already an advertisement
Well,
to which you have already applied.
well, I have, no, there is no bar for.
In your interest, I'm telling you,
My lord.
don't get a dismissal order, take a withdrawal order,
My lord, I leave it to you.
isn't it?
Lordship.
If something goes wrong in your selection process,
Then he can come, Lordship.
no, after the dismissal order. It's your choice.
Okay, well, I do it.
You're Mr.
Take care, sir.
Mr. A.K. Hussain and the counsel for the petitioner prays for withdrawal of this petition. Stop. Mr. K. Gogoi, the standing counsel, appears for the
Lordship, I am for respondent 1 and 2, Lordship.
higher education.
Lordship,
Department.
Lordship.
Stop. The petition is dismissed on withdrawal.
Lordship.
Hello.
11.
Yes.
Matter relating to handing over the charge of merger school, my lord. And at your lordship will find case number 31, my lord. This is the order by which the 115 school was merged with the base school. And after the merging the school, the headmaster of the merger school has not hand over the charge to the base school. And accordingly, the department issued the several orders. Your lordships will find case number 36.
Which is the best school?
Basic school is the Malot 338 Charnots are Kandapara LP school. This is the basic school. And Marzi school is Tilarpar LP school.
Yes.
Yes. Thereafter, Malot DO issued the order to the BO to take the necessary action for handing over the charge of the Marzari school to the basic school. But the headmaster, Malot, your lordship will find 36 minutes. But headmaster of the Marzari school ignoring the communication, Malot. Your lordship will find the page 36 minutes. Thereafter, Malot, show cause notice was issued to the that headmaster, Malot, of the Mars school, Malot. That is page 38 minutes.
Yes.
Thereafter, my lord, petitioners being the member of the SMC, my lord, filed the representation before the DO, my lord. That is your page, my lord. Your lordship find the page 40, my lord. Page 40, my lord. This is the petitioner, the member of the managing committee, my lord. That was filed, my lord, 12/5/2023, my lord. No action has been taken, my lord. Due to non-submission of the charts, my lord, the students who are marched to the basic school, they have been deprived from the midday meal, my lord. This is the problem, my lord. As per the notification, my lord, movable or immovable property should be marched to the basic school. And all the charges should be marched. All the charges should be handed over to the basic school, my lord. But the respondent number, my lord, had the private respondent had ignoring the departmental communication, my lord. And that's why the petitioner, being a member of the managing committee, has filed the representation.
What happened after the show cause notice?
My lord, thereafter, my lord, after show cause notice, no, my lord, reply has been submitted by the private respondent, my lord, totally ignoring the facts, my lord.
Yes.
Basic grievance is against the respondent number 5 million, the private respondent whose services were provincialized in the 2021.
No, that's fine.
Malad.
But then you have issued a show cause notice.
We have issued a so cause notice.
What happened after that?
Malad, that instruction I'll have to take. But the contention which has been raised by the petitioner that the movable and immovable property has to be handed over. That's not correct, Malad, because their services were provincialized under the 2017 Act. And once the school is merged with the base school, Malad, the property of that school vests with the government, Malad, not with the base school. At this stage, Malad, let notice be issued, Malad, because it's
I see the page number 29, office memorandum, Malad.
Page?
Page 29, Malad. Malad, page 29, Malad. Point C, Malad. Movable and immovable property of schools shall be based in the name of the base school after merger, Malad. This is the office memorandum, Malad.
But that
It was
will not
issued, Malad,
override the
21.
provision of the statute, Malad. 2017 Act section
But
5.
I am not on the movable immovable property, my lord. Why the charge has not been given? Due to non-submission of the charge, my lord, students who are marched to the basic school, they have been deprived, my lord.
Okay, your good name?
R. Islam.
R. Islam. Issue notice. Mr. You are appearing for?
Malad, the elementary division, B question.
Learned Standing Council, Elementary Education, address for respondents,
1, 2, 3, and 4. Malad.
1, 2, 3, and 4. Petitioner to take steps for service of notice on respondent number 5 by registered court within 1 week. Respondents are allowed to file contract after it. List the matter after 4 weeks. 4 weeks.
Malad.
Well,
Yeah, please, Lordship. The petitioners, Lordship, hearing Lordship, they were appointed as an
assistant teacher in AMI school in Nagaon in 1999. Their services were also regularized. Thereafter, Lordship, they were put to a screening process. And by an impugn order, Lordship, they have come with a plea that in Nagaon district, only one number of candidate was found to be working. And Lordship, this petitioners, present seven petitioners, along with another seven, had approached this honorable court in 2018. But due to during that said process, Lordship may kindly see annexure 20, page 108.
Yes.
Lordship, the petitioner number 2, Bipul Hazarika. These are the present petitioners in page number 109, serial number 6, serial number 9, serial number 10, 11. Lordship, again, they were left out in that said process, Lordship. But the other petitioners, their services were provincialized as tutors. Now, Lordship, recently this honorable court has disposed of several writ petitions. I am praying for a similar order at page 153. Page 120, Lordship. They will be subject to a so-called Lordship, and Lordship, till such time, Lordship, our services may not be disturbed. The operating portion, page 125, Lordship. Similar petitions, Lordship, 6 number of similar petitions have already been disposed of. Only the paragraph 2 will be changed, Lordship. Other will remain same. And in that case, Lordship, there are 5 number of petitioners. In the present rate, Lordship, there are 6.
Paragraph 2 is?
Paragraph 2, Lordship, the details, Lordship, I have given in my petition, page 8, Lordship. Only that paragraph 2 will be changed, Lordship. Otherwise, the other part of the order will remain same. But in the said case, Lordship, there are 5 number of petitioners. In the present rate petition, there are 6 number of petitioners. 7. 7.
Yes, what is?
Lordship, with similar order may be given, my lord. If your Lordship comes to page 153, 153, paragraph 10. The show cause notices should be issued within, my lord, page 153. Yes.
Yes.
My lord, page 153, paragraph 10. That may be reflected. Paragraph 10, the show cause notices should be issued within the outer period of 4 weeks from the date of receipt of the certified copy of the order. Petitioners be given sufficient time for about 4 weeks to submit their show cause reply, and thereafter the competent authority, that is the DE, Assam, shall give an opportunity to the petitioners of elementary education, petitioners of personal hearing, and make an endeavor to dispose of the proceedings.
1 minute.
Same order. All the
That
6.
is already the page 124.
Yes, same order.
Same order.
Lordship, I have no difficulty if that part, that order is also given.
That
Same
order, this order
That
may
is
be.
already there in
Yes,
para
Lordship,
10.
that paradigm is already.
My lord.
But Mr.
SK Das.
SK Das, then also.
These are next 2 orders.
Also heard Mr.
A. Fukan, your lordship.
A. Fukan, then the standing council,
Elementary education.
elementary education department. Any other respondents?
No, my lord. 1 to 4. I'm appearing for all the respondents.
What are the details?
Page 8, Lordship, paragraph 3, Lordship. I have given chart, Lordship. Page 8.
The petitioner number 1 was appointed on 18/5/1991, correct?
Lordship.
In Dhupguri KPR Girls and School. Nagaon district. And her service was regularized on 18/5/1999. Stop. Petitioner number 2 was appointed on 26/10/1991. in Chota Rupahi ME Madrasa. And his service was also regularized on 19/5/1990. Stop. Petitioner number 3 was appointed on 18/2/1993 in Nakurijan MS School, Naugam district. And his service was regularized on 13/5/1990. Stop. Petition number 4 was appointed on 29/9/1990 in Diubali, Jakarwa MS School, Naugam district. And her service was regularized on 33/1999. Stop. Petitioner number 5 was appointed on 26/7/1991 in Bhirberry ME Madrasa, Naugam district. And his service was regularized on 13/4/1991. Stop. The petitioner number 6 was appointed on 20/10/1991. And his service was regularized on in Chota Rupahi ME Madrasa, Naugam district. And his service was regularized on 19/5/1999. Stop. You were appointed as what?
As assistant teacher also.
As, we know, as in so school, huh?
And Lordship, in page number 124, in paragraph 9, there are 5 petitioners. In this case, Lordship, it would be 6 petitioners.
And you just type out on page 122.
Paragraph 9 and
up
paragraph
to page 125.
and in the
And,
last.
in para 9, it says show cause notice to 5 petitioner, here to be 6 petitions.
6.
And para number
15.
15. There also it will be 6 petitions. That's all. Yes.
Oblas.
May I please, Your Lordship? My lord, there was an advertisement in the month of February for inviting applications for filling up 3,887 posts in LP school as assistant teachers. I applied, being eligible, my lord, and second provisional list was out. That is annexure 4, page 34, my lord. My lord, relevant page is 36, my lord.
Provisional list.
Second provisional list. My lord, got page 36.
Yes.
My lord, last 72 serial number.
Oh.
My lord, one thing is important, my lord. It is in the women reservation category, and my lord, last 2 columns, the total marks is 215.8 and withheld. And though it is 72 total count, if your lordship on top, total count is 82, my lord. On top, my lord, on top of the page, total count is 82. My lord got it. Exactly on top, total count 82. And this is 72. I was in serial number 72. My lord, your lordship may come to next page.
What date is this?
My lord,
8/5.
that is 8/5/2023.
Then,
My lord, the next page is page 37, my lord. My lord, this is important, my lord. As your lordship has seen, my lord, this second provisional list, my name was withheld. It is for information of all the candidates who are kept withheld in the second provisional merit list for the post of assistant teacher of LP schools and assistant teacher and science teacher of UP schools against advertisement so and so. They are requested to attend a physical document verification as per schedule given below. My lord, the date is given 15/5/2023 and 16/5/2023. My lord got the date, my lord. My lord, I attended on 15/5. I've shown everything. Everything was okay. Then the final select list comes next, my lord. In the final select list, my lord, my name is not there. And if your lordship looks at the page 40 and 41, 40 and 41. My lord, 40, your lordship got it, my lord.
yes.
My lord, the total marks, if your lordship see the second last column, in respect of 71, it is the exact same mark which I have got, 215.8. But all others from 72 till 82, all the marks are less than me, my lord. Less than me. Now, I get when I go over there and say that lots of people getting less marks, they've been selected, and why I'm not selected, though my name appears in the provisional merit list. Then I get then I come to know, my lord, page 7, annexure 7, page 43. That a notice was issued on 14/5 that all the persons whose withheld candidates, they were supposed to appear on 17/5 and 18/5.
Earlier it was
15/5. And my lord, this notice is 14/5. I appeared on 15/5. Notice is 14/5. This is the subsequent notice, and it says on 17/5 and 18/5. Your lordship got it, my lord. I was not aware of this. And plus, my lord, 14/5 is the notice, but 15/5 I appeared in pursuance to the earlier notice.
that time nothing was said to you?
No, nothing. In fact, they were satisfied with my everything. But my lord, the thing is, if in this notice, if your lordship looks at page 46, clause 2, the candidature of the candidate who failed to attend the said physical document verification will be cancelled forthwith without assigning any reason. On that technical ground, you wash away everything which otherwise I eligibly achieved as per the provisional list. My lord, if your lordship looks at the page 42 once, 42. It is not that I was the isolated candidate. If your lordship looks at page 42, serial number 82, marks wise is much below me, but remarks columns it is withheld. My lord got it. My lord, see the note 1. The candidates marked withheld will be appointed only after confirmation of genuineness of the credentials through a physical document verification. The schedule of physical document verification will be notified shortly. My lord, why not this opportunity was given to me?
This is a final list.
Yes, in the final list, in respect of a withheld candidate, they are saying we are going to do it again.
Yes,
Your lordship, in this matter, we would like to say, my lord, the appointments have already been given, your lordship. Already the selection has taken place. They, my lord, have come so late, my lord. If there was any this thing, they should have come before, my lord. And as far as this thing goes, my lord, notice may go, my lord. Only notice may go, my lord. Because already the selection and appointments have taken place, my lord.
No, posts are still there. That is the reason I have shown, my lord, page 42.
Let me get my instructions, my lord. Let me get my instruction. Till then, my lord will not, my lord, notice me only go. My lord. I'll get my instruction.
Then I won't issue you notice.
Then,
Just take
then my lord will.
My lord, only thing, if your lordship, prima facie, if I could prima facie satisfy your lordship that in a very negligent manner I've been dropped out, then this note 1, which is given in page 42, this opportunity should be given to me also, my lord. Because
that was given to you in the provisional list.
yes, I've given. I've attended on 15th. On that day, they did not say that 14th we have given another notice like yesterday. You come on 17th. They did not say that they have examined everything.
My lord, he was not diligent enough. He was not diligent enough. Now he's come to court, my lord. My lord, let me get my instructions, my lord.
We'll see, yes. Hurt Mr. J. Abidin and consider. Mr. Profant, standing counsel,
Elementary education.
elementary education shall take instructions in the matter. I'm giving a short date.
But my lord, a short date, only one thing. If this candidate who has been withheld in page 42 in the final list, even my position could have been withheld, but they removed me totally from that final list. The saying that candidate marked withheld will be appointed only after confirmation of genuineness of their credentials through physical document verification. That means another opportunity is there for this 82 number, page 42, if your lordship see it once.
List the matter on 12.
I'll get the instructions, my lord.
Monday.
Monday.
My lord, can it be on, my lord, Wednesday, my lord? A little later, my lord. Because,
My lord, let it be on Monday. On Tuesday, I'll be from Tuesday, next 1 week, I'll be out of station, my lord.
Then
a little after that, my lord.
1 week you're out of station.
My lord, for some medical planning, I'm going to.
When are you coming back?
I'm going on 13th and I'll return on 18th.
19th,
19th.
But only, my lord, there is only one hardship is there, if your lordship permits. My lord, this page number 42, mark is only 214. Your lordship got it. But in the meantime, if they do the physical verification, that person will be appointed. And then they will
I'm
say.
saying Monday. I'm saying Monday.
That is the reason I'm saying let it be on Monday, my lord. This
Okay,
coming
let
Monday.
us try Monday.
Let us try Monday, my lord.
I'll try, man.
Well,
Deeply obliged.
May I please? My lord, at the outset, my lord, I beg apology, my lord. One annexure, my lord, annexure number 2 and 3, my lord, were placed. It have been 2, 2 should be 3, 3 should be 2. My lord, may permit me to correct it after the, my lord. My lord, the issue with regard to holding of a charge of a post of.
You're the caveat.
It's a caveat, madam. It's holding of a charge of a post of principal in Boginodi Higher Secondary School. My lord, the issues are very limited. My lord, went for deputation, B.Ed deputation. I completed my B.Ed. I then, my lord, applied for permission to undergo MA course in ASPIS. The permission was granted to me by the inspector of schools. I underwent that course in open line mode from the Dibrugarh University. Now, after this, I am senior to him. There is no dispute on that. Then, my lord, all of a sudden, a hearing is held in the office of the director. And therein, my lord, a gradation list which was prepared from the school is also there. Therein also, my lord, I am senior. Now, my lord, I have not been able to annex the order by which he has been allowed to hold the charge. Now, he has been allowed to hold the charge. And when I inquired, I was told that I did not have permission to undergo that MA course. So, my lord, they have given him and my MA course because MA is a requisite qualification there. If my lord comes to page 27, man.
Yes.
My lord, this is the list of teachers in the school. Serial number 2 is Binod Bosumatari, the petitioner, my lord. My lord, his date of appointment, initial joining is 92. My lord may come for that MA 2022 from Dibrugarh University, NOC enclosed, then B.Ed. My lord, Dibrugarh University, he went on deputation copy enclosed. Now, my lord would come to the private respondent, that is serial number 3. My lord, he joined in the year 1993, junior to me, my lord. He completed his MSc in 1990. Now, BA 2014 from Dibrugarh University, my lord, he is not deputed, but NOC issued by the then principal. So basing on an NOC issued by the principal, he completed it. In my case, my lord, I did the MA with a permission from the inspector of schools. And still, my lord, I have not been given this. And he has been allowed to hold the charge. This is my case, my lord. How can a senior who is otherwise eligible be superseded by a junior? If my friend has something, my lord, concrete other than this, what I know, my lord, then it would be a different question. Otherwise, my lord, that is an order which calls for interference from my lord.
Where's the order?
And the order, my lord, I could not annex. I have made a description of that number I have given. The order copy, my lord, I could not get it. I tried everywhere, I could not get it.
Without the impugn order, Lordship.
If I have made a statement, I don't have that impugn order. If you don't give it to me, ma'am, where will I get it, my lord? Nobody is giving me that impugn order.
My lord. My lord, the petitioner is the, my lord, Anil Kumar Gomez, respondent number 4, my lord. He is the postgraduate teacher, my lord. And the petitioner is the graduate teacher, my lord.
Who does it?
And seniority never come a different cadre, my lord.
What is it?
Page 27, kindly see, my lord. It is, my lord, page 27, my lord, Anil Kumar Gogoi is a, my lord, postgraduate teacher, my lord, of the higher secondary, my lord. And the petitioner is the graduate teacher, my lord. And the respondent number 4 is the senior most teacher among the postgraduate teacher, my lord.
Yes, respondent number?
4, my lord.
Anil Kumar Gogoi.
And second thing, my lord, the petitioner having no essential qualification is because, my lord, kindly see rule, my lord, 2018 rules, my lord.
What rules?
Assam Secondary Education Provincialized Service Rule 2018. Page number, my lord.
32. Education to principal.
Principal, recruitment of principal.
Page 30.
The minimum qualification, my lord. My lord, kindly see, my lord, 12, my lord, sub, my lord, 3, my lord, the minimum qualification for appointment to the post of principal in high secondary school and senior.
Which one are you reading?
My lord, page 32, my lord, rule 12.
Sub-rule 3.
Sub-rule 3.
Yes.
And my lord, lastly, my lord, Roman 5, my lord, kindly see, my lord. The age of the candidate must not be more than 57 as on the 1st January of the year of recruitment. Not he has, my lord, remains, my lord, less than, my lord, 3 years, my lord. At now, my lord.
What is it?
My lord, he ought to have been retired on 3/1/2025, my lord. Date of retirement, my lord. And as on that, my lord, he is more than 57, 58 years, my lord.
Affidavit shows it's 58 years.
58 years.
So as per rule 12, sub-rule 3, Lordship 5, Lordship, the age of the candidate must not be more than 57 years, Lordship.
It's more than 57 years, my lord.
Yes.
And second, my lord, the hearing is conducted, my lord. Public petition also, my complaint also placed before the hearing, my lord. And thereafter, my lord, the director took a decision to hold up in such headmaster in favor of me, my lord. But this, my lord, petition has not been brought on record, my lord. Even, my lord, impugned order also not on record, my lord. Not annexed, my lord.
He has given the details of the impugned order.
Fine, ma'am.
My lord.
And my lord, also the details of the order that was passed by the director, because director held a hearing, that orders were never given to me. My lord, this is a direct recruitment post.
Then we'll call for the record, my lord, from the director, my lord.
My lord will have the records. My lord will have the matter on Friday or Monday, whenever it's convenient to your lordship. Let the records be produced. Man.
There is a complaint petition, my lord.
And my lord, one more thing. My lord, he did his B.Ed with a permission from the principal. How can that degree be held to be valid? That also, my lord, let the director come and give a clarification. These two things, my lord will have it on Monday. I'm well. It's enough.
A council as by Mr.
A Boro, my lord.
A. Boral, council for the. Okay, I heard Mr. K. Bhattacharya, then the council for respond number 4.
R4, my lord.
Respond number 4.
Mr. S.M.P. Chishti. Then the standing council,
Secondary education for one student street.
secondary education. Shall receive instructions as well as produce the reports. Stop. Then the standing council shall also take instructions. Whether the. Where is that, is it B.Ed?
B.Ed, my lord, B.Ed.
Whether the B.Ed degree obtained by the respond number 4 can be held to be valid on the basis of no objection certificate
Given by the principal.
issued by the principal of the said school.
After a week, not this Friday lawsuit, let it come next week lawsuit, any date next week.
Monday, my lord, no problem. Monday,
Wednesday lawsuit, mechanic. Wednesday.
Monday, man. Much obliged.
Okay, we'll do it on Wednesday.
Wednesday, man. No problem.
Obliged. Okay, we have to discharge, my lord.
Oh, yes.
I my lord, I local.
To नाम देखा जाए, नाम देखा जाए. Much obliged.
Obliged.
15.
May I please your lordship, this matter is looking after by Santanu Bora lordships, kindly pass over for time being lordship. He is another for lordship,
This
pass
is
over time being lordship.
For some time.
$56 of supplementary list. Order. 56.
May I please lordship? Kindly adjourn the matter for the day lordship. My senior Mrs. A. Gan, her mother-in-law expired lordship yesterday.
Have you given your mention slip?
Lordship? No lordship.
Why?
Lordship, we didn't have a contact number of the petitioner lordship.
Yes.
My lord, in this case, even notice has not been issued. My lord may issue notice then.
Let us wait for us. But Mr.
M. Ali.
M. Alil and the council for petition on request made on behalf of
P. Rafa, on behalf of Mrs. A. Gayan.
A.
A. Gayan.
On request made on behalf of MSA Gayan, then it's standing, CGC.
CGC lordship.
When do you want?
Lordship next month.
Why next month?
Lordship
Next
will
month.
take some time.
Monday.
Wait, I have a 15 days to valid.
The data ta koi.
After 2 weeks?
Okay, lordship.
My lord, date may be fixed. My lord, this petitioner is suffering. My lord, he is running from pillar to post for since 2019.
23rd. June
13.
23rd.
Obliged.
Obliged, lordship.
57.
Next is lordship, this letter regarding compassionate appointment lordship. The father of the petitioner who was died in harness 27/12/2004. After his death, the mother of the petitioner was applied lordship 3/3/2005, but her claim was not considered on that time. And that time the petitioner was a minor. After age of majority and passing ages, he applied, the representation was 20 number page lordship. The petitioner representation and page 20 lordship.
Yes.
And a standard form of application, page number 22, Lordship. But still, her claim was not considered, Lordship, the DLC.
Still not considered.
Yes, Lordship.
In this case, Lordship, initially, Lordship, petitioner's mother applied, Lordship, in 2005. And the petitioner, Lordship, the petitioner, two wife, Lordship. First wife is also, Lordship, alive, Lordship. Petitioner's mother is the second wife. And she is also daughter of a Lordship, second wife, Lordship.
Second wife is eligible,
And
Lordship.
First wife, sons and daughters is all, Lordship, I have, there is a factual, Lordship, there is dispute, Lordship, the first wife and second wife, Lordship. Whether second wife is, Lordship, not a legally married wife, Lordship. So how she can apply, get apply for Lordship,
Lordship, the
compassionate
page,
appointment, Lordship.
page number 14, kin certificate. The second wife also a legal hire, Lordship. I am annex the kin certificate. First one and
And
second wife,
Lordship,
both
page
name are,
20, Lordship.
One
both
minute.
name are there, Lordship. Page number 14, Lordship.
Yes.
First wife is, Lordship, is there, Lordship, in Akhtarun Begum, Lordship, she is the first wife, Lordship. And she is not made a party, Lordship, here. And Lordship, page 20, Lordship, where it is a Lordship, family pension is also sanctioned in favor of the first wife, Lordship. Page 20.
Page 20 is
Here,
application of the petition.
here it is mentioned, let's say, in the number 2, Lordship, paragraph number 2, that after death of my late father, Abbas Uddin Chaudhuri, the family of the deceased have been facing much financial due to sudden stoppage of the regular salary income drawn by the deceased, though the family pension is sanctioned to the Aftara Begum Chaudhuri, the first wife.
Yes.
So second wife is not entitled for a compassionate appointment, Lordship.
No, the second wife is just
Now,
son of the
in,
petitioner.
a petitioner is the daughter of the second wife.
Oh, daughter of the petitioner.
Yes, Lordship. Initially, Lordship, second wife is applied in 2005. And I have to take instruction, Lordship, what happened to this application, Lordship.
That's what I'm asking you only.
Yes, Lordship. And Lordship, whether the first wife is also applied for compassionate appointment or not, Lordship.
He is not eligible. The criteria, the second wife is eligible. He is a some educational qualification. That's why second wife is applied in the year 2005, Lordship.
Okay, your good name?
A Begum.
Third MSA Begum, then it's also. MS Didi Barman, then government. Shall receive instructions. Whether the application dated 13/6/2018, correct?
Yes, Lordship.
Made by the petitioner for appointment of constitutional grounds has been considered by the concerned DLC. When do you want?
After 2 weeks.
At least the letter.
Did
16 and 17 of daily admission.
Wait, Mr. Lordship. Lordship, kindly pass over the matter only for the timing, Lordship.
What?
Lordship, the conducting council is on next, Lordship, only for the timing, Lordship.
Sometime after some.
18.
Bless, Lordship.
No, my lord will peruse the last order. It'll be visually not right? Well, it's an order dated. 19, 45, ne? 45. 19.
Eight, respondent eight.
Petition dismiss করবো maintainable নহয় title should or title if you are order select photo not maintainable.
Affidavit has been filed.
My lord, not that we have not received any copy till now, my lord.
This matter is handling by Mr. Rajesh Majumdar. So my lord, can the matter may be taken any other day, my lord? I have
Lordship,
to ask.
yes.
That is the matter.
My lord, Mr. R. Majumdar had appeared. He was directed to have his, let it be taken up in his presence.
Any other day, my lord, any other day.
When do you want? Any other day means when?
Wednesday or Friday?
Okay.
My lord, let them file their affidavit. My lord will have it on Monday, my lord. Let them file their affidavit in the meantime, my lord.
But you can have any counsel, senior counsel, assistant minister, M. Khan.
Khan, my lord.
Then counsel for petition. See, it is not.
Amen.
On request made, and we have also heard Mr.
My lord, I
Yeah,
am
we
appearing for the respondent number eight, my lord.
Yeah, Buyan for
My
the respondent number
Eight, my lord. They have marked,
eight.
my lord.
So,
My lord, in this petition, my lord, they have challenged the title suit and title appeal order, my lord. Whether this is.
My lord, let my friend not confuse the matter. The court had come to a narrow finding
I
on
am
the
not
last occasion.
confusing,
Let that
my lord.
instruction.
I am referring the prayer part of the writ petition. There is nothing to confuse, my lord. Prayer part of the writ petition says, my lord, that can be considered, my lord,
on request
maintainability.
made on behalf of R. Majumdar, the standing counsel.
Elementary.
Elementary, secondary, no? Elementary.
This is the matter again on Monday. 12th.
12th, my lord. Lordship.
Obliged.
15. Concern.
क्यों ना चाहते
Actually, it's taken up, I think, 15 words. 15 words.
Is it 15 minutes?
Yes.
Here the petitioner who is the assistant teacher in a LP school, my lord. She is paying for rectification and correction of her date of birth as recorded in her service book, my lord, which is wrongly recorded.
When did you enter service?
I have joined in my service in 2006 June, my lord, as an assistant teacher. The fact of the case is that the petitioner who was appeared in the HSLC examination in the year of 1985, where it was recorded her date of birth is 1/3/1967, that is annexure 1, page 18A. But at the first attempt, she could not success, my lord. Thereafter, she again appeared on 1991, where the Board of Secondary Council has recorded her date of birth wrongly as 1/3/1963. And the 1/3/1963 and 1/3/1963 is recorded in her service book, my lord. Thereby, her date of retirement should be according to 1/3/63. Her superannuation period is 1/3/2023. But actual date of birth is 1/3/1966. Then that her date of superannuation is 1/3/2027.
So by now you are already superannuated.
Superannuated.
No, till that the department did not give any release did not release my service
Is
minor.
that correct, Bora?
Yes, my lord, but why now, my lord, he's CSU, he is superannuated because on, I have calculated it, my lord. On 3/6/2023, he is 60 years, 3 months, 2 days. Why now superannuated? And after superannuation, there cannot be age correction, my lord. At the same
But
time, lordship will turn to
petitioner
page number
is still in service.
28.
Are you still serving?
Yes, my lord.
Have you made your statement to that effect?
Yes, and minor kindly come to the annexure.
Bora, you take instructions whether petitioner is still serving or not.
But so at the same time, lordship will kindly see the page number 28.
No,
The service book,
no, lordship.
service book, page number 28.
And annexure 7 is 27, where the deputy inspector school issued a letter to the controller of examination, verification of the date of birth in respect of Rohila Basumatari, 80A446 non-Udalguri LP school. With reference to the subject cited above, I have the honor to forward an original application received from C. Rohila Basumatari, so and so, for correction of her date of birth. It is seen that admit card of SSLG examination in 1985, serial number so and so, her date of birth is 1/3/1967. However, as per admit card of SSLC compartmental examination 1991, pass out certificate, her date of birth is 1/3/1963. Therefore, I would like to request kindly verify the matter and clarification of the date of birth of Srimati Rohila Basumatari for age verification of her service book. But nothing has been done by the board of, so my notice may go. And
Have you completed the secondary?
yes, my lord, yes.
Court of Secondary
Yes,
Education?
yes, my lord. As a respondent number 8.
Lordship will also see the next page, page number 28. This is the service book. Clearly written is 1/3/1963,
Yes, that is what I
and
am
he has
saying.
signed it on and countersigned by the block administration on 16/12/2009. After signing and everything, my lord, now after the superannuation, he has come before the court to correct this.
But she is still in service, my lord. She is not released by the authority, as there is a confusion between the department itself. That is why I am coming before this court.
He gave the examination 1985, and till today there is no correction of the.
She had
admit card.
submitted an application before the Board of Secondary Education on 23/12/2022 for correction of her date of birth in admit card. That is on annexure 9, page 31. The name of the candidate, date of birth to be corrected 1/3/1967. At this stage, notice may go.
See, your service book was opened in the year 2009, correct?
Yes, my lord.
There you have appended the signature. You are serving as what?
As an assistant teacher.
Assistant teacher. There it is shown that it is 1/3/1963.
Yes, my lord. And time and
And
again,
from 2009 onwards, you're keeping silent. Only in 2022, you start making applications.
that is true, but
That by itself defeats your case.
no, my lord, at this stage, when notice may go, because that
There
her
is
date,
no notice.
that her date of birth is actually, but they are wrongly, but petitioner is not.
What were you doing from 2009 to 2022?
The time and she has not communicated with the office maybe, but when at the time of retirement,
Basically, the idea is very clear
but at the
that you
time
want
of
to continue
retirement,
longer in service.
she came to know this thing before.
Where is your first admit card?
That is annexure 1, page 18A.
Page 18, it's absolutely clear, my lord. It is here given examination in 1985.
Yes.
Though in my particular date is not clear.
And
From 1985, she failed to correct this admit card.
and in admit card, but school, school certificate issued by the principal, there where it was stated in 1/3/1967. My lord.
I am also relying on a division bench. This is this exactly similar situation. After that correction is made, that is not allowed. My lord. This was rejected, my lord. This is the division bench decision now.
Maybe she ignored that. She's maybe she ignored about the fact while. at the time.
Have you given any explanation? What you were doing from 2009 to 2022? Yes, Boro. Is she still in service?
Yes, my lord. She
I
is
don't
still in
understand, but
service.
she cannot be in service because she has crossed the age of 60 years.
Don't
I
say
can,
she cannot be.
I can get the instruction, my lord. I will get the instruction.
Instruction, then
Yes,
She'll
my lord.
fix it in.
I will take.
you know the law.
No, it's absolutely clear, my lord. If
The
he's-
department did not release her.
she cannot continue beyond 60 years.
She cannot continue beyond her date of birth, recorded in the service book. Till it is correct.
And that instruction, I'll get, lordship will fix it on Wednesday.
Day after tomorrow.
Day after.
Yes, my
We'll
lord.
get a telephone instruction.
Her MS.
A. Bujar Barua.
A. Bajar Bora, let me confirm. Only person who has Bora. You're not? Your standing counsel?
No, I am appearing for 4, 5, 6, and 7 for BTC. my lord.
You're not standing counsel BTC.
No.
List the matter on. 14th, no, 7th.
No.
7. Must.
Problem.
19, at least.
Lordship, we have received a copy of the affidavit in opposition filed by the respondent number 3. Sometime may be granted for.
Respondent 3 or respondent number 1?
R1, my lord, that's not 1. File it on 31st of May, my lord.
Okay. You want to file your plan?
Yes, we want to file the price.
You're good now?
G. Rengma.
But G. Rengma, let us also put the petition. No. Just cancel it. Mr. G. Rengma, let me also put it. Submits, price for how much time?
1 week's time.
Price for which time? To file reply to the counter affidavit filed with the respondent number 1. Please allow, release the matter after 1 week.
Only lodge.
Pledged.
20.
On the last occasion, my lord, Lanet, 10, my lord, stating that, my lord, the similar situation pending before the Supreme Court, my lord.
Who appears?
My lord.
Lordship, I'm appealing for SN number 3, CBS.
Hmm.
Earlier, there was limitation, limitation period was
No,
there.
you said similar matter is pending
Similar matter, Lordship, has disposed of so many
Already
cases.
disposed.
in the Supreme Court.
Supreme Court judgment. Lordship, this is the judgment.
Let us see.
Paragraph 93, 94, Lordship may kindly go.
Have you got a copy?
No, my lord.
No, he's
Just
not
no,
aware of the
I have-
judgment. He's not aware of the judgment.
Take the matter after a week, my lord. In the meantime, I verify, my lord.
1 minute.
93, 94, Lordship, kindly go. Submit the bill. No, public document like this.
This is stating only the facts. Where is the finding?
What? Lordship,
Where is the finding?
last paragraph, Lordship. Last paragraph finding is there. One 95. Paragraph.
Yes.
My lord.
On request made by Mr. Yeah, but Kiril and the counsel for the petition. When do you want?
My lord, fix on Friday, my lord. I gone to the judgment, my lord. Friday, my lord.
Fine.
Oblige.
Oblige.
Please, Lordship. This matter relates to, my lord, the post of in-charge headmaster, my lord. The petitioner was the assistant teacher of original high school, my lord.
Going to file one, if you already copy has been served us. As per direction of the honorable court, I have filed additional affidavit, lordship.
When?
Today, lordship. I
And
have
that
some
simple
copy.
information they have brought that,
After 1 week, lordship.
simple information they have brought that he has joined as a ad hoc. That can be brought in by 22, 23, 20. I love, since 20, he is holding the in-charge headmaster.
It come, lordship, because as per direction of the honorable court, I have filed this.
I love, previously record.
Lordship,
Heard Mr.
MJ Burwa.
MJ Varol and counsel. MS
RB Bora,
RB Boral and
council BTC.
standing counsel PTC submits that she has filed in addition after this morning. Stop. Registered to verify and press the same of record, comma, he found in order. Stop.
A direction was previously given to top list, top of the list, my lord. There is a direction of this honorable court to.
This the matter
Correct to some.
after 1 week.
14.
After 1 week.
My lord, date may be.
Lordship on 14.
14.
16th.
16th, all right. 16th, if possible on 14th, 16 I will be outside. Then after. All right. I like.
My lord, in this case, my lord, government side has filed affidavit. I'm appearing on behalf of the private respondent. We have not served copy, my lord. Copy be served to me, my lord.
ফাইল কৰিছে বোলে গভৰ্ণমেণ্টে এইবুলিও কয় মইতো কবি পোৱা নাই Any other day,
The matter relates to my respected senior friend has said that, my lord, he has not been served with the copy of the affidavit, my lord. In fact, my lord, we are the petitioners and the copy was long back served on us. My lord, nothing is there, my lord. They have reiterated this report is there, my lord. If my friend wants, my lord, I can give him a copy right now, my lord.
my lord. Any other
And
day, I have to
some-
see, my lord. I have to
Some
make up my
urgency
mind.
is there in the petition, my lord, as I have been deprived of from the charge of the headmaster of
Date
this
will be
school,
given, my lord.
my lord. So that's why, my lord, some urgency is there, my lord. We are hoping that the matter can be disposed of, my lord. Have you served a copy?
Hello? Yes, we have filed our application,
Have you served a copy on SICTA?
not yet.
Serve him a copy.
Yes, my lord, any day.
We'll take up next week, after 1 week. My lord, on next Tuesday or Thursday. You want it on the hearing day? My lord, that will be better, my lord. But yeah, Brian, then we counsel for the petition. MS, and Fukan, then it's standing council, no,
Yes, madam.
which department?
Elementary.
Elementary department. Is directed to furnish a copy of the counter affidavit to Mr. A. Shikta, then the council appearing for his phone number.
My lord, I am private respondent, my lord.
Number six, my lord.
Private respondent.
Ranjan Kumar Chanda. The matter,
I am 6.
may I pray for 13th of June, my lord? My lord. 13th of June. Oblige me.
Deep love language.
23.
May I please, your lordship, matter may be taken after some time.
Why?
My senior election code number 20, lordship, our matter is going on that code.
What number?
Code number 20.
Up to some time.
Yes, Malad, but otherwise, Malad, the relief which they are seeking under the 2011 Act, man, that has gone, Malad. Within 2016, this act
Then-
was struck down. I
Then-
think, Malad, Lordship can dispose it of, directing the authorities to look their case under the new act. Malad.
I'm not understanding.
At best, Malad, that is the relief they are.
Let her senior come, she is not understanding.
24.
Make clear, Rosh. My lord, in this case, respondent is supposed to file affidavit, my lord, for education. Well, till date, no affidavit has been filed. Earlier, many occasion directed. I have challenged the impugn order, my lord, by
Have you filed your
We are
counter?
still awaiting instruction. Malad.
Why?
earlier, 2 occasion, I think, my lord, directed for filing affidavit by the education.
Service completion. I think the service is also not completed. Malad.
No, my lord, service upon private respondent number 4 already.
They are
my lord,
challenging the
served,
appointment of the
but he
private
did not turn, my lord. As per Lojima court order also, my lord.
Number service on number 4 is complete.
Yes, my lord, but he did not appear, my lord.
2 weeks further time may be given.
And my representation is also pending before the direct.
But you didn't counsel for the petitioner. Mr. Mr.
One thing I'm praying, my lord, my representation, I filed it before the director, which was pending, my lord. If lordship,
Let him file his affidavit now, it's too late. Mr.
Be cautious.
B. Kaushal, standing counsel. Standing counsel,
Secondary.
secondary education department, it's allowed 2 weeks time. to file counter.
it may be last chance, my lord. Lordship may fix that.
Sorry.
Lordship may fix a date, my lord.
Why? Let it come after 2 weeks.
25.
Most of it.
Matter, your lordship, my lord. But this matter is relating to provincialization of service of the teachers by entire schools, my lord. The requirement is, my lord, that is 2009, up to 2009, there are two dice codes to be issued. The recognition must be made on 1/1/2006. And they must be land, etc. My lord. If these are the qualified, they're entitled to the provincialization. Now you'll kindly say page 95, my lord. Page 95.
Yes.
Yes. This list, my lord, because actually there is no specific order, but they have uploaded one list in that my lord website. Where your lordship will kindly see, my lord, the next page 96, serial number 15. 15. School. Serial number 15 is, my lord, petition number, my lord, 17 and 18. Serial number 15, your lordship, kindly see, my lord. Name of the school, your lordship got it, man. They are here, my lord, two petitioners. What they have written in the remark column, your lordship, kindly see, dice code was issued, dice code issued second, it is for 2007-2008. Then you'll in the except the right column, my remark, teacher's name not appeared in dice code up to 2011-12. Similarly, rest petitioners serial number 23, your lordship, kindly see. Same thing, my lord, petition number 3 and 4, same thing written, my lord, right side, my lord, 11-12. Now I take to your lordships this, my lord, requirement of the law. Your lordship kindly have, if this book is there, my lord, just take to your lordships to section 2Z. Section 2 within bracket ZB, my page 107, your lordship. Page 107. This is regarding LP school, man. Two within bracket ZB, my lord. Page 107. Your lordship got it, man.
Yes.
Venture upper primary school means, sorry, madam. Venture lower primary school or venture LP school means a school imparting education up to class 5 and established by the people of the locality prior to 1/1/2006, whose name figure in the dice code up to 2009-10. And prior to that, and whereof the service of the teachers have not been provincialized under any act enacted by the state legislature so far. Provided that the dice code shall have to be issued on or before 2009-2010, and dice code issued thereafter shall not be considered for the purpose of provincialization. Now they have written, my lord, we do not have dice code of 11-12. This is not the requirement. The requirement is 9 and 10. Then you will kindly see next, my lord, page 108, my lord, conditions to be fulfilled. Section 3, my lord. Section 3 of eligibility criteria for selection of educational institution for provincial servicemen. Here, your lordship, I take your lordship to number 1. Venture educational institution which have been established and obtained the required permission, recognition, affiliation, concurrence as the case may be, required for the concerned institution from the respective authority prior to on or before 1/1/2006. Your lordship got it, man. 1/1/2006. So again, my lord, second also provides a 1/1/2006. So everywhere, my lord, this 1/1/2006 is there. Then I take your lordship to page 122. Oh, sorry, 120. Section 113, my 113. Page 120. Your lordship will find 13, section 13, my district scrutiny committee and the state level committee. There shall be district scrutiny committee in each district separately for elementary, secondary, and for higher secondary education to scrutinize the service records and other related issues of the service teachers of provincial school to provincially of the services. The deputy commissioner of the district by an order shall constitute
the district scrutiny committee for the respective district under preceding subsection, provided that in case of newly created, that another aspect, the district scrutiny committee for higher education, we are not concerned, my. Then my you will kindly see page 122. Then I will come to page 122. Page 122, man. Yes. 6, subclause 6, my. The district committee, your lordship. I'm just showing my all these efforts already, exercise already done. This 6 matter, the district scrutiny committee shall first scrutinize and prepare a list of all bench education institutions within the district. That is subclause 6, I'm reading, my. Which are eligible in terms of provisions of science also. So my case is, my lord, all the exercise, my lord, which I have shown to your lordship, it has been already completed and found eligible. Thereafter is recommended by the district committee, the state committee. Everything was done. Now, while provincial service, they have written that their name do not appear in 2011-12. Nowhere, nothing is there in the act, my lord. This 10 and 11. And all the exercise have been made and found that I am eligible. District scrutiny, scrutinized it, deputy commissioner, headed by deputy commissioner. It was gone into, it was sent, and ultimately everything was done. Okay, everything was found okay, my lord. Now, only because of this, which is beyond the act, beyond the rules, beyond the law, my lord. So for that matter, I am before lordship, my lord, for ends of justice. We are serving here long back, my lord. And all similar situated persons have already been taken over by the law. And director's affidavit also there, your lordship. Director filed an affidavit, respondent number 2. He also said 10, 11, their name do not appear. It was filed, my lord, on, I think, 7/11/2022. Director, page 105, your lordship, it starts. Yes, man. Page 106, paragraph 4, your lordship. That the petitioners have approved this honorable court for provincialization of the services under the Assam Education So and So Act. Petitioners are agreed by the rejection of the claims for provincialization services under the so and so, while opposing the pair. Answer and dependent submit that as per clause 13(6), which just now I have referred to, my lord. The district scrutiny committee shall first scrutinize and prepare a list of all bench education institutions within the district, which are eligible in terms of provision of so and so, and shall thereafter proceed to scrutinize and verify the service of records of all the serving teachers who are eligible and would become eligible for being considered for provincialization service. Accordingly, the DEO submitted the proposal for provincialization of service of the following teachers against the school with recommendation of DSC as per the Act of Science. So district committee recommended, headed by deputy commissioner. So with the recommendation of DC, my lord, they have submitted it. Next, your lordship will find, except only one person about some doubt they have stated about serial number 9. That maybe, my lord, I am not disputing that fact, my lord. Now, your lordship, though in the writ petition, it is seen that the name of Begum, that I am not disputing, my lord. Number 5, accordingly, DU Assam placed the proposal of the district scrutiny committee before the state level committee, as well as joint committee constituted by the government under chairmanship of so and so, to examine the proposal for provincialization service, so and so. Subsequently, as per minutes of the joint committee meeting held so and so, decision was taken to instruct the mission directors to verify the following DICE related documents. That is, my lord, whether the name of the schools appear in DICE code of 2009 or before, whether the names of the incumbent appear in DICE data of 2011 and afterwards. This is not required. Then enrollment. Then thereafter, SSA submitted the DICE verification report with the name of the petitioners do not appear in DICE of 2011-12. That is what they are saying again and again. So this is my humble submission, my lord, that this is not at all a requirement of the law. Whether my name is there 9 and 10, whether my institution recognized 116 prior to that, whether I am having that in the schools or not. So this is the case, ma'am. Now, joint committee, they cannot go to joint committee. That is beyond the law. They are to the district level committee, it will go to the state level committee, that is done, that is enough. Now they cannot send to some other committee, madam, which is not it is not envisaged by the provisions of the law. And if they do not want to give me, they may make any committee and they get it done from that committee, madam. This is what they might have done it, madam. My question, madam, is whether I fulfill all the requirements as mentioned in the act.
So your case was rejected.
No, not rejected. They have stated my name do not appear, that is the petitioner's name, in 2011-12.
So that's why. On
That
that
is
basis, on that basis.
They have not given any letter to us, but that from the website, my lord, our school's name is there. Against that school, this is the written mine. So ultimately rejection, madam, not provincially on that ground. So whether that ground is tenable or not, that here was to be still.
Who rejected your?
Rejection, madam, in the fact, madam, this is the page 95, which I have annexed, my lord. The list given by the government, website. The website of Director Elementary Education, who is the authority to for the matter that.
Yes, Kaushik.
But under this act, my lord, there are two committees, my lord. Now, our stand in the affidavit is that though the district scrutiny committee initially recommended, but as per the dice code verification done, my lord, their names were not found in the dice code of after 2011. Now, my lord, this is a requirement under the act, my lord, section 4. Your lordship will find. The definition which my lord senior has shown is the definition of the venture school. The school which has their name in the dice code up to 2009 or before. Now, section 4, my lord, provides who will be provincialized, my lord. Section 4, may I read it, my lord? Subject to fulfillment of all other provisions of this act, the services of the teacher and tutors of all venture education institutions eligible under section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in the official gazette, and they shall become employees of the state government with effect from such date. Roman 2. Roman 3, my lord, is important. Must have rendered at least 6 years of continuous service as on 1/1/2017 from the date of joining in the concerned venture educational institution, which must be on 31/12/2010 or prior to that date. So, my lord, the requirement of the teacher's name in the dice code has to be from 2009-10 to 2017. And it is the only basis from where we can ascertain whether the teacher was there or not. Because at the venture stage, we did not have any control over the school. So dice data is the only data, my lord, from where we can ascertain whether they have.
But where was that? Where it says only 2009? Dice got. Which section we were reading earlier?
The definition was referred to at 10 space 107. 2ZB.
But I effort, my lord.
Yes, venture school.
My lord. Ventures lower primary school or venture LP school means a school imparting education up to class 5 and established by the people of the locality prior to 1/1/2006, whose name figured in the dice code up to 2009-10 and prior to that, and whereof the services of the teachers have not been provincialized under any act enacted by the state legislature so far, provided that the dice code shall have to be issued on or before 2009 and 10, and dice code issued thereafter shall not be considered for the purpose of provincialization of service of any employees of the institution. So, my lord, for becoming the venture lower primary school under this act, bring under the definition of this act, my lord, the requirement of their dice code having prior to 2009 and 10 is required. Now, my lord, section 4 provides.
Proviso, read the proviso.
My lord, provided that dice code shall have to be issued on or before 2009
and dice code issued thereafter shall not be
Yes.
considered for the purpose of provincialization.
Yes.
So, my lord, if a school doesn't have the dice code of 2009 and 10, and they have the dice code after 2009 and 10, they will not come under the definition of the lower primary school, my lord, under this act. To come under the zone of consideration of provincialization under this act, my lord, they will not come under the definition of the lower primary school if they don't have the dice code prior to 2009 and 10. However, for provincialization of the services, their continuous service of 6 years is required. That's section 4. And that we can ascertain only from the dice code. So the district committee, my lord, recommending some name, my lord, that will not confer a right upon them until the state level committee has recommended. Because the statute provides, my lord, there are two tiers, my lord. One is district level and the state level.
Section 4.
Section 4.
Yes, section 4. Page 114.
114. So these are the criteria which has to be fulfilled for provincialization. For this case, my lord, we are concerned with Roman 3, my lord.
Yes.
No, that is our case, my lord. That because the petitioner's name that was not there after 2011, my lord, and therefore they doesn't fulfill the criteria under Roman 3. We cannot say, my lord, whether they were continuously serving.
But their names were there in 2019.
19, my lord, the school.
No, no.
School must have been there. The ZB is the definition of lower primary
Come
school.
to page 99.
My lord.
Page 99. Not 99. 98. 96. 96.
96. The repetition.
Yes.
Ma'am.
Petition 96.
Page number 15.
My lord. Both teachers' name not appeared in dice data up to 2011 and 12.
Then that column 4.
Two 2007 and 8.
7 and 8. Then the next column.
Then serial 23, 20.
It is the dice code number 2009 and 10.
For 2009 and 10.
9 and 10.
So for 9 and 10, they were there.
My lord, the dispute is not that, my lord. The dispute is that the school may have the dice code of 2009 and 10, but the petitioner services, because it is the services of the teachers which will be provincialized. Now, my lord, to look into section 4, Roman 3, my lord, that whether they had been continuously serving since 2009 to 17 or not, that we can ascertain only from the dice code. If the dice code doesn't have their name, meaning thereby, my lord, the teacher was not there in the school. And the dice definition under this act, my lord, it is the dice which is prepared by the SSA and maintained by the NUPA, National University of Planning Administration. And there is a portal, my lord, where every year the dice code are uploaded, and there's no scope of rectification of that dice code after it is uploaded after freezing. And therefore, my lord, the dice data of the NUPA, if they doesn't show that 2012, 13, their names are not there, it means, my lord, they were not there in this school.
So if they're not there in the school, they cannot be.
They cannot be provincialized, my lord, because
They require 6 years.
yes,
Continuous. service.
yes, there has to be a 6 years continuous service.
Is there? We are having it more than that.
Now, how do you say that you have?
The appointment letter is there, we have annexed, my lord, everything we have given. More than 6 years, my lord, is there. My lord, you will kindly say the definition of employee. Employee in the act, my lord, the employee, my lord, whose service have to be, my lord, that,
That we have seen.
yes. Definition employee, my lord. What of the- 103, my lord. 104. 103, my lord. Employee. 103, J, my lord. J. Employee means and include all serving teachers and tutors, as the case may be, of international institution who have been appointed and joined in the concerned so and so school as on first day of January, and whose service are being or would be provincial under this act. So we fulfill all the conditions, my lord. We have-
No, issue is this. What they are saying is your names are not there in the dice code up to 2011, 2012. Correct.
It is their condition. I am not saying, man. They are saying my name do not appear.
Now, how do we know that you are there?
This is already recommended district scrutiny committee. It already recommended, my lord.
But the dice code, which
Yes.
is maintained by the SSA,
My lord.
your names are not there.
My requirement is 9 and 10. You also have seen, man. They have scrutinized it. District scrutiny
No,
committee.
no, no. 9 and 10 is for the definition of venture schools.
Right.
But for the purpose of provincialization, then the section 4 will come. If I'm
Yes,
not
you'll
wrong.
kindly see, my lord. Yes.
Yes. Section 4, Roman 3,
Section 4,
subclause 3, subclause.
page 114.
Subclause 2. Roman 3.
Teachers and the tutors to be permitted under the act. That is my lord. Must have been working as a teacher in the concern as a student as mentioned in section 3(1) Roman 1. That have been recognized by the competent authority on or before 1 on 2006. Now 3(1)(1), kindly have a look to that minor section. 3(1)(1) Roman 1. Page 108, my. The venture institutions which have been established and have obtained the required permission, recognition, affiliation, concurrence as the case may be, required for the concerned institution from the respective authority or authorization on or before 1/1/2006, provided that permission of the first year of high, that is my, that is a higher secondary. We are not on that, my. So this is the requirement as per 3(1)(1). Where it is written, my lord, that it is not the requirement or that their name should appear that, my.
This with regard to the school. Venture educational institution.
The venture institutions which have been established, right?
On or before 1/1/2006.
6, my.
Oh.
So it institutions also recognized, we are also there, my. We also.
What about section 4?
Yes, section 4. Section 4 will 114.
Close 2.
Yes. Section 4. Subclause 2, section 2. 4(2), madam. Yes. 4(2) must have been working as a teacher in the concerned institutions as mentioned in section 3(1)(a), Roman 1, have been recognized by the competent authority on or before 1/2006.
Of that institution.
Of that institution. We are in that institution, fine.
No, that's right. Come down.
Then must have minimum, then must have rendered, you're also referring, I think, must have rendered at least 6 years continuous service as on 1/1/2017. 17. I have given a chart, where you also will see it is more than that.
Where is the chart?
Yes. From the date of joining, as you student, which must be on or your next must be on of 31/12/2010 or prior to that time. The chart to who? Page number 7. Dice code is always for the institution, man, not for employee. Dice code always for the institution because institution, if exists, if it is found to be legally in existence.
No, when the
Institution.
dice code is given,
Yes, man.
names of the teachers are reflected. in the
Certainly, madam.
institution.
So,
Correct.
so 9,
So
10,
your names are not appearing in the dice code.
which one? 11, 12, where is the requirement? 9, 10, whether my name is there.
No,
or
no,
not.
no, 9, 10, that is a different thing. That is for the venture school.
No, madam, you lost.
Fixation of venture school.
Madam, just.
Let us be clear on this.
Even my lord, the
uh,
instruction which the SSA was asked to be brought on up, even in 9-10, the dice code, this petitioner's name were not there. School name was there.
Then
but
how the school district committee has recommended our names?
my lord, that
I
is
do not come
why
out of it. They have not disputed this thing also in the affidavit. What they are saying, their names do not appear in the 11, 10. So 10, 11. 11, 12. Their cases, this is the case, madam. Their names do not appear in 10, 11. Now, page 7, you'll find my chart I have given. Page 7 of my writ petition. Date of appointment and how many years I have completed my.
How many petitioners are here?
Here 9. 9 schools, 18 petitioners. 2 teachers. Page 7, your loss kind is serial number, your loss will find. That one, date of appointment, 15/2/1, period of service as on 1/1/17, 15 years, 10 months. Your loss, you got it, man. Appointment letter also annexed, my lord, it is also there. It is supported by appointment letters. Then, my lord, number 2, 21, as on 17, my lord, 6 years, 6 months. All are more than, my lord, 6 years, man.
We'll take up at 2.
That's too much.
As your lordship has rightly gone through section, I will be joining in a short time here. Section 4 to your lordship is very
That
clear.
I've seen, that I've seen.
Yes,
Now I'm confused in everything,
must have.
except the fact that give me some documents of
Lordship.
materials that you were working from so and so time for the past 6 years.
Your lordship will kindly take up page. I have page number 23. From 23 onwards, all the writ petitioners who have approached before your lordship, I have given all the appointment letters indicating the date of their appointment, your lordship.
This is 2010, isn't it?
Lordship,
2010.
10. On 26, 2010. The
That to be shown working from what date was it? 1/1.
before 31/12/2010.
on or before from 31/12 to 2010.
He must be working on or before 31/12/2010, your lordship. Even they have not disputed these things, your lordship. Their only grievance is that name has not come in the dice code of 11/12, your lordship. All the appointment letters I have annexed,
No, appointment letter is fine.
lordship.
Continuation letter?
Continuation letter, lordship, that I cannot give. Therefore, the district scrutiny committee is there. Lordship will kindly see what is the purpose of establishing this district scrutiny committee. 2 committees have been enunciated by this act. One is the district scrutiny committee, who will first verify all the records.
No, that's fine.
And then it will go to the state level scrutiny committee. Once the state level scrutiny committee also approves, it is for the government to issue the appropriate orders, your lordship. Now, what happens, your lordship? They have above and over and above these 2 committees, they have constituted one more committee saying joint committee, which is not there in the act, Now, the fact that they have been approved by the district scrutiny committee after verification of the records, both teachers' records as well as the records of the school, both things are to be dealt with by the district scrutiny committee. Both things are to be dealt with by the state level scrutiny committee. Once that have been done, your lordship, now they will come and say even they have not annexed any of the dice showing that our names have not been there, because dice code is maintained by the department, your lordship. The schools were in the venture stage, your lordship. Oh, I cannot come and say that please insert my name in the dice. It is to be maintained by the department.
You have the dice code, Kaushik?
SSA have the dice code. I will file an affidavit giving all the names of the dice code.
Then you file your affidavit.
I'll file.
Otherwise, this is the whole issue. The whole crux of
Yes.
the issue is that their names are not there in the dice code. Now, if you
I
show
have the chart
something.
of the, I will fix it. I will next it.
Even otherwise, if dice code, if their name is not there,
But the first question is whether, my lord, 11 and 12, it is required or not. If that is required, my lord, then of course. Or if suppose my name is there, my student name is there up to 9 and 10, as per requirement of the act, my lord. Whether they can go beyond that, that may be clarified by them, my lord.
Heard Mr. H.R.L. Chowdhury, senior counsel, assisted by Mr.
M.H. Laskar.
M.H. Laskar, the counsel for the petitioner. Also heard Mr. B. Kaushik, is in the learned standing counsel,
Elementary education.
elementary education. On request made by S. Bora, learned standing counsel assessor. How much time you require?
Already, idea also time given, my lord.
Yeah.
We are suffering your loss.
2 weeks time is allowed to file complaint. You make sure you file.
Obliged to. If date if possible, my lord, because if possible, subject to your lordship.
2 weeks, give a date,
23rd.
23rd.
Obliged to, obliged.
46 of daily order.
Yes, Majumdar, what is your case?
Lordship, here in this case, Lordship, petitioner earlier approved this honorable court, Lordship, honorable single judge pass order against me, Lordship. Then I approach the division
What is
bench.
this title suit?
Lordship, just I am coming the division bench order, writ appeal, Lordship.
Where is that order?
Writ appeal order, Lordship, page 154, Lordship. It is operative portion, Lordship, page 155.
1 minute, 1 minute.
Last,
1 minute.
sorry.
Yeah, page.
Page 154, Lordship. Operative portion, Lordship, page 156, Lordship.
1 minute.
May I read, Lordship? Last 2 paragraphs, Lordship. After hearing the learned counsel for the parties, we are of the opinion that whether the state authority will be willing to grant SIU approval at the stage after the petitioner has reached the age of 57 years or not is an issue which can be considered by the state authority. However, the assertion made by the learned counsel for the repeat appellant that the appellant's application for grant of SIU approval is under process is not denied by the state respondents, Lordship. In their affidavit, they have stated that there is a process, Lordship. Under these circumstances, we allow the appeal by directing the state to consider the application filed by the writ application applicant for grant of SIU approval as per the aforesaid letter dated 35/2017, as well as the statement made by the state in their affidavit in opposition filed on 20/11/2020 and Chapter 22, which also reflects that the matter is under consideration. Accordingly, the impugned order dated so and so passed in so and so is set aside with a direction to the respondent to complete the process which is pending before the authorities as indicated in the aforesaid documents as expeditious as possible, preferably within a period of 2 months. Lordship, accordingly, I filed, but by virtue of the government advocate's letter, Lordship, page 158 is the order, operative portion, page 159. Last paragraph, Lordship, I read. Therefore, the government is requested to issue necessary instruction to the undersigned in compliance of the order of the Honorable High Court dated 13/5/2020 passed in writ appeal number so and so, and in view of the legal opinion provided by the standing counsel communicated by letter so and so. This government is a kind consider information and necessary action. Then, Lordship, page the secretary passed the order, page 160, Lordship, Annexure 26, Lordship, operative portion, Lordship, 161. In the 161, Lordship, last paragraph, in the meanwhile, the so and so was dismissed by the Honorable High Court by assailing the order. The petitioner preferred writ appeal, which was allowed by order dated 35/2022 by directing the state respondent to consider the application filed with the appellant for grant of SIU approval as per DE Assam letter so and so. Matter was moved to the senior standing counsel, Lordship, without adhering to the order of this division bench, Lordship. Their effort moved it to the Senior Standing Council Elementary for views, and he has reiterated that the earlier letter offered to the Finance SIU department. In view of the above fact and circumstances and view of the Senior Standing Council Elementary Education Department, that no right has been accrued in favor of the petitioner appellant for appointment, hence her claim for appointment as assistant teacher has been rejected. My respectful submission, without passing any independent order by virtue of the passing of the order of the readable, Lordship, the learned government advocates issued some instruction, Lordship, or letter, whatever may be. The Secretary to the Government Education Department, Lordship, passed this order. So at this stage, I pray, Lordship, let the Secretary pass an independent order without influencing the order of the letter of the senior government advocate. That part may kindly consider, so that
Obviously, he has to take some advice, isn't it?
yes, but not like that, Lordship. Not like that, because the writ appeal has specific direction is there to consider the
Where is that writ appeal again?
writ appeal page 156, Lordship. Last paragraph, under these circumstances, 156, Lordship, we allow the appeal by directing the state to consider the application filed by the retailer for grant of SIU approval as per the aforesaid letter dated so and so, as well the statement made by the state in their affidavit in opposition filed on auto, which is also reflected that the matter is under consideration. That affidavit, Lordship, I am referring the Lordship that a government affidavit, page 148, Lordship.
Page
148.
government has filed affidavit.
Earlier writ petition, Lordship. 148 page. Paragraph 6, Lordship. That thereafter the case of the petitioner was forwarded to the government for first time on 28/2/2004 necessary order by the Deputy Inspector of School, Hailagandi. Although various communications were made thereafter, however, due to non-receipt of the SIU approval, the case of the petitioner could not be considered. The SIU proposal was submitted by the DE Assam on 12/6/2014, and accordingly, the DE Assam was asked to furnish a detailed report showing the chronological development of the matter for further action by letter dated so and so. Assam was further asked to submit a select list of Hailagandi district as referred to CR number so and so. Clarification: if there is any specific order from the court in favor by so and so. Accordingly, the Commissioner Secretary to the Government of Assam was provided with the details as sought by letter number so and so. Lordship, prior to that, Lordship, 148, the case of the petitioner, paragraph 6, up 2 lines, Lordship. The case of the petitioner was considered during the time since the she did not approach this authority with her particulars. So my respect to submission, once the readable order is there to consider the SIU approval, which is also, Lordship, I have annexed the SIU approval, page 1 for SIU approval 133, Lordship. It was submitted on 31st May 2017.
My lord, we have not filed our affidavit.
You'll have to file your affidavit,
My lord, we will file in detail affidavit.
So
but don't take too long.
My lord, 3 weeks time. my lord.
may I pray, Lordship, because all records are here, let the secretary may consider, Lordship, reconsider the matter, hearing me,
Let the
Lordship.
secretary file an affidavit with regard to his order.
Lordship, because once the retake, my resolution submission, Lordship, once the retake order is there, Lordship, how the senior government advocates, by virtue of that, that he is saying that I have no right, maybe, but without application of mind of passing any order on the SIU approval, which is
So
pending.
we'll see on the basis on the.
A
affidavit.
short date, my Lordship, I pray, Lordship,
Okay,
because
Let me come to the petition. On request made by Mr.
PK Bora, my lord.
D.K. Bora, Learned Standing Council,
Elementary education.
Elementary Education Department. I'll give you 2 weeks only,
My lord.
2 weeks time as last chance.
My lord.
10 days, maybe, Lordship, with all respect.
22 meter, my
Time
lord.
as last chance is allowed to file contract.
A fixed date may be given, Lordship.
The matter on 21st June,
25th June, Lordship.
21.
21 June, Lordship.
Extra copy may be given. One extra copy.
Finish, do you have an extra copy?
Read petition, Lordship. I already served. In spite of that, I will serve because I have no objection of that, Lordship, because
26 admission.
God bless you. The petitioner is not there, madam.
26.
None appears for a petition. You're Mr.
I'm S Das, my lord.
S. Das.
I'm appearing for 1 and 3.
Standing council,
Higher education.
higher education appears for 1 and 3.
I got 2 minutes.
And Mr. S.P. Mehdi,
For 2.
Leonard, CGC,
No, my lord. For standing council, AZ, my lord.
standing council,
AZ, accountant general.
accountant general appears for responding.
And 4 is also appearing.
And for the board, responding board, letter,
MS,
D. Baru-Jari.
D. Barujari for responding.
Actually,
List after 2 weeks.
27.
Finally, there is the order dated 10 through my lord 2023, my lord. Whereby directed to produce some records, my lord.
You have the records?
not.
Yes, proceed.
By this revision, I have challenged the my lord impugned order, my lord. Kindly see page 23, my lord. Whereby, my lord, one private respondent, Sam Saran Thakur, is appointed as a my lord, the president of the governing body of the BP Sulia College. And my lord, the said my lord, private respondent is the my lord, faculty member of the said college, my lord, and he is the lecturer under education department, and he retired in the year 2020, my lord. And subsequently, he was appointed as a president of the by the governing body, my lord. Kindly see, my lord, annexure 2, page 20, my lord. It is the office memorandum. There is a bar, my lord. Page
Yes.
20. In partial modification of the yellow offense, following terms and conditions added and modified regarding constitutional structure of the governing body of the colleges. Henceforth, one so retired principal from a college shall not be considered for appointment as a president of the governing body in the same college unless a minimum of 5 years have elapsed since his and her date of retirement. And second, my lord, no faculty member, either retired or in service, shall be considered for appointment as president of governing body, the same college, unless the minimum 5 years have elapsed from the date of retirement. The private respondent retired on my lord 39 or 39/2020, my lord.
Yes.
Yes, because that's why my lord I have challenged.
Retired as?
Retired as my lord lecturer, associate professor, my lord.
Yeah.
The education department. My lord.
Who's appearing for private respondent?
We have filed it. Call up now, my lord.
No affidavit has been.
File our affidavit, my lord.
We may be given some time, my lord, to file our affidavit. And here, my lord, accept petition number. Five and six, my lord, all have been deleted, my lord. And in this case, my lord, affidavit was shown by petition number 1. He has been no more part in this case.
Respondent number 5,
His name has been deleted from the petition number.
and their student, my lord, son and daughters, my lord, studying in the college.
And
That's why, my lord,
therefore, my lord, this petition, my lord,
Who has shown the affidavit?
petition number 1. And he has already deleted from the petitioner.
Then
well, on that basis of that, my lord, that affidavit, my lord, that this honorable court passed order, my lord, 10-2.
And they have no Lucas Tandy also, my lord.
this is one aspect you'll have to think about.
My lord. My,
I'll give them time to file the
Close.
affidavit, but you think about this.
my lord,
You may have to file afresh,
my lord,
or you want to save time and file afresh.
my lord. I'll let this go. No, affidavit. File it's a press affidavit, my lord.
Withdraw this.
No, my lord, but
How can you file a fresh affidavit?
my lord, regarding my lord, respondent number 5 and 6, petitioner number 5 and 6, my lord. The 9 petitioners, my lord, some
9 petitioners, I think,
now represented, my lord.
only 2.
No, my lord. Now 2, my lord. Petitioner number 5 and 6.
Only two petitioners are surviving,
My
5 and 6.
5 and 6.
And six also, my lord.
Affidavit was shown by the respondent number petition number 1.
And six
My lord.
also not a guardian, my lord.
Whatever it is,
Lordship.
Now, my lord, I have filed affidavit on behalf of petitioner number 5 and 6, my lord.
where?
File local of number. Earlier, my lord, earlier a set of counsel appeared, my lord. Subsequently, my lord,
Your additional affidavit is also shown by the petition number 1.
my lord.
How can this be? When did you file this? 21st December 2022.
I may be allowed to, my lord, press affidavit, my lord, regarding.
How can you file a fresh affidavit?
But, my lord, I am appearing for the petitioner number 5 and 6 now, my lord.
That's why
My lord.
it is shown by the petitioner number 1.
And on that
Petitioner
basis,
number 1 is no more there.
my lord.
Then
And I am also, I am appearing, my lord, 5 and 6, my lord.
5 and 6 you are appearing, but this writ petition is shown by whom?
Petitioner number 1, my lord.
Then-
Yeah, lord.
Then
And on that basis, my lord, order passed on 10-2, my lord.
maybe it was passed,
My lord.
but then today we are finding out that petitioner number 1 has shown this affidavit. He's no more here.
My lord.
Only 5 and 6 survives. What do you want to do now? It's up to you. You think over it.
Lord,
On this technical ground, this writ petition may go.
my lord. But in respect of petition number 5 and 6, my lord.
That's why 5 and 6 can file a fresh writ petition.
My lord, liberty, my lord. Can take.
That's why liberty
My
is good.
My lord, my lord,
That is better for you.
my lord, my lord,
Otherwise, at the last end,
my lord.
Mr. K. Patkiri, the counsel for the petition. Press for withdrawal of this writ. With liberty to file a fresh. Mr.
A.R. Provincial Lordship,
A. Tabildar, Leonard,
all 1 and 2.
Leonard, Funding Council, Higher Education,
Lordship,
appears for 1 and 2, and Mr.
R. Oliver.
R. Ali, Leonard Council, appears for respond number 5.
3 to 5.
3, 4, and 5. Lord. 3, 4, and 5. So, dismiss on withdrawal with liberty as per.
Records may be sent back. Records may be sent.
Yeah,
Definitely.
you can send back the reports.
That may be not the record. That may be recorded.
The records may be sent down to the respective department, to the department.
Online.
28.
Report is sent back to the department.
Wait, listen. Here the petitioner challenged the impugned order at page 31, my lord.
30?
31, my lord.
Yes.
I am reading, my lord. Due to non-compliance of RTI information from the authority concerned, Sri Abdul Rauf HT Uttur Swapata LP School is hereby removed from the HT CAM member secretary of the said school with immediate effect, and MD Khalil Uddin Sheikh AT Uttur Swapata LP School is hereby allowed to act as head teacher CAM member secretary of the said school with immediate effect. The main one, my lord of Bilal Hussain has filed an RTI application, my lord, by seeking some information, my lord, at page 19. Accordingly, my lord, the petitioner, page 19, the RTI application, my lord.
Yes.
I am reading, my lord. Necessary information. I have needed the photocopies of school certificate of the head teacher of Uttur Swapata LP School from primary school to HSLC. Then from when the Uttur Swapata LP has been maintaining by the ad hoc committee along with the photocopy of the earlier list of committee approved by the district elementary education officer Dhubri. The details of the withdrawal and expenditure of the student midday meal and dress from January 2021 to 38 2022 of so and so and so. Then, my lord, page 22. The reply was submitted by the petitioner, my lord. Page 22. Application date thereof not possible to furnish it. Petition not specific. There is no mentioning of a specific food expenditure, dress expenses for the students, so and so, so and so. On being agreed by the applicant, my lord, he has referred an appeal, RTI appeal, my lord. Before the BO, my lord, accordingly, my lord, the petitioner submitted the reply, my lord, in the appeal, page 27. Page 27, my lord. Here stated, my lord, due to shortage of time, he could not furnish the documents, my lord. Accordingly, my lord, the BO referred the matter to the DO, my lord. Accordingly, my lord, the DO at page 28 issued notice to the petitioner, my lord. Page 28. Issued notice for hearing in the first appeal, my lord. Subsequently, my lord, the impugned order has passed by the DO, my lord. But under the RTI Act, my lord, the first appellate authority only has the jurisdiction to dispose of the RTI application. Only, my lord. He has no jurisdiction to remove or etc. or impose any penalties, my lord. Section 19 of the RTI Act, my lord.
Give a copy.
Right to Information Act 2005.
Yes, proceed.
Yes, my lord. Section 19 of the RTI Act, my lord, appeal. If any person who does not receive a decision within the time specified in subsection 1 or clause A of subsection 3 of section 7 or is aggrieved by a decision of the central public information officer or the state public information officer, as the case may be made within 30 days from the expiry of such period or from the receipt of such a decision, prefer an appeal to such officer who is senior in rank to the central public information officer or the state public information officer, as the case may be in each public authority. Then, my lord, subsection 6, my lord, bottom. An appeal here, my lord, appeal was prepared under subsection 1 of 19. Then the jurisdiction, my lord, of the appellate authority, subsection 6. An appeal under subsection 1 or subsection 2 shall be disposed of within 30 days of the receipt of the appeal or within such extended period not exceeding a total of 45 days from the date of filing thereof, as the case may be, for reason to be recorded in writing. My lord, this is the only jurisdiction of the first appellate authority, my lord. And the second appellate authority has the jurisdiction to recommend for disciplinary action, my lord, which is provided section 20 of the RTI Act, my lord. Section 20, my lord, last 2 line, my lord.
Yes.
My lord, section first appellate authority has no any jurisdiction to impose any penalties, my lord, or remove the authority, my lord. Only second appellate authority has the jurisdiction to impose penalties, my lord, under section 20. I am reading, my lord, section 20. Or the Central Information Commission or the State Information Commission, as the case may be, at the time of deciding any complaint or appeal, each of the opinion that the Central Public Information Officer or the State Information Officer, as the case may be, has without any reasonable cause refused to receive an application for information or has not furnished information within the time specified under subsection 1 of section 7, or malafidly denied the request for information or knowingly given incorrect, incomplete or misleading information or destroyed information which was the subject of the request or obstruct in any manner in furnishing the information, it shall impose a penalty of 250 rupees each day till application is received or information is furnished. So, however, the total amount of such penalty shall not exceed 25,000 rupees. Then, my lord, provided that the, my lord, this is the only jurisdiction, my lord. But the DO, my lord, has removed the petitioner from the post of head teacher.
DO is the first appellate authority.
Actually, my lord, the first appeal was preferred before the BO. But the BO forwarded to the DO after hearing was conducted by the BO itself also. My lord, kindly come to page 28. This is the notice. Sir, madam, in enclosing herewith a copy of letter number so-and-so dated 6/2023, along with its enclosure received from the BO, Bilashivara, I am to inform you that a hearing on the matters relating to appeal, first appeal petition of Bellal Hussain is hereby arranged on 8/2/2023 at 11:30 AM in the office chamber of the undersigned. And the BO already conducted the, my lord, first hearing at page 24. Although the BO has conducted the first hearing on first appeal, my lord, but subsequently again the matter was referred to the DO, my lord, at page 24, my lord. First appeal hearing issued by Mizanur Rahman Bhuya, his Block Elementary Education Officer, Bilaisipara. Accordingly, on 30/11/2022, hearing was conducted, my lord. And on 30/11/2022, my lord, the petitioner submitted the reply, my lord, at page 26 and 27.
Yes.
So, my lord, the input order, my lord, absolutely in violation of the RTI Act provision, my lord. He has no authority to remove the petitioner from head teacher to, my lord. Only he has the authority to dispose of the petition, my lord. Appeal petition, my lord.
We are yet to file our affidavit, but your lordship will find that the
And the
it has been
petitioner, my
said,
lord,
though in the impugn order it has been said non-compliance of RTI information, but it reveals well from this so-called notice that page 25. The so-called notice reveals whether there was a direction from the authority to act upon the RTI application. And having not done, my lord, this is an insubordination. And moreover, my lord, the head teacher in an LP school is not a substantive post, my lord. There's no post as such head teacher. There are two teachers in an LP school, my lord. Among them, one is given a charge of the head teacher, and for that, he gets 300 rupees as an additional amount. So this removal doesn't amount to a punishment. my lord.
It may not amount to a punishment, but the way he was removed.
My lord.
yes.
Language speaks different, isn't it?
Yes, this the language says due to non-compliance RTI information.
Hmm.
But my lord, it seems well from page 25 that there were direction to him to furnish the RTI information.
That is this show cause notice. What happened to this show cause
My
notice?
lord, that I'll take the instruction. my lord.
That
Whether
is
this
also, my lord.
the removal is outcome of this so-called notice or not. Well, what he is trying to project that this is a punishment imposed upon the petitioner as per the RTI Act. But it seems well this is a outcome of the so-called notice. my lord. Though my lord, the words are not so specific. Let me have the instruction. my lord.
Your Mr.
My
Hurt.
lord, the page 25, the show cause notice was issued, my lord, because the petitioner has not furnished the record, my lord.
That
Information.
will see.
Yes.
You,
And the,
your
my
good
lord,
name, please.
M. Hussain, my lord.
Hurt M. Hussain.
My lord, the petitioner going to be retired on 31st of July, my lord.
Okay. Mr. B. Kaushik. Then standing counsel,
Elementary.
elementary education shall take instructions. Whether the removal of the petitioner as head teacher of Uttar Swapata LP school is on the basis of the show cause notice dated 6/12/2022 issued by the Block Elementary Education Officer, Bilasipara. Please, the matter again on. I'll give you 1 week time,
my lord.
14th.
My lord, actually, my lord, the show cause notice was issued by the BO and removed by the DO, my lord.
That's what
Yes.
it was.
Yes. 14, my lord. Oblige.
May it please, Your Lordship. But the matter relates to the withdrawal of the recognition of the petitioner's B.Ed college, my lord, which was established, my lord, way back in 1993, my lord. On the last, my lord, when it was moved, my lord, on
12/5/2023, matter was posted for interim orders, subject to furnishing of the necessary instruction. And thereafter, by order dated 18/5/2023, further instruction were called. And today was fixed for consideration of the interim period. Now here your lordship will find the petitioner is one of the premier institution of the district, and it is the only institution in the Tinsukia district and functioning since 1993. Prior to NCTE Act came into play. And subsequently, when it came the recognition as necessary under the provision of that act, it was granted. The last was granted in 2015. The whole trouble started from 2019. A so-cause notice was issued, saying that the certain deficiency that they have found, that is with regard to the approved faculty list, which is not as per the NCTE regulation. The lordship may kindly come to page 52. This is the order. Lordship may come to paragraph 3, or other paragraph 4. And whereas the institution has submitted reply dated 11/6/2019 and 3/7/2019 in response to so-called notice received on 1/7/2019 and 12/7/2019, the ERC in its meeting in its 275th meeting held on 26 July 2019, after considering the matter and observed that the institution is still deficient on the following grounds. That is, approved faculty list is not as per NCTE regulation 2014, as 3 teachers are part-time. This order was appealed against before the appellate authority. The appellate authority passed the order. You will find at page 56. And lordship may come to page 57. Starts from 56. Lordship may come to page 57. And whereas the second paragraph, and whereas appeal committee noted that appellant institution was required to submit the above documents by a so-called notice dated 21/2/2019. Appeal committee noted that appellant institution has been able to rectify the deficiency relating to approval and appointment of faculty on full-time basis, which is stated as reason of withdrawal of recognition in the impugned order dated 26/8/2019. Appeal committee further observed from the building plan that the BCC that appellant institution does not possess the required built-up area, which is stated to be so-and-so square feet. Minimum built-up area required for conducting B.Ed program with an intake of 50 seats is 1,500 square meter. The built-up area related to norms have been enforced since NCTE regulation 2009, and they are requirement to be followed by all teacher education institution according with clause 811 of the NCTE regulation 2014. And whereas appeal committee noted that though inadequacy of built-up area is not cited as a reason of withdrawal, the appellant of its own was required to submit evidence of possessing required built-up area as per terms and conditions of revised recognition order dated 22/5/2015 and the so-called notice dated 21/2/2019. Appeal committee therefore decided to confirm its impugned order of withdrawal dated 26/8/2019. Similarly, the notice was issued, so-called notice was issued for deficiency of a particular ground, but the appellate committee has found that whatever the ground was cited, that has been fulfilled. That is not the ground, but they have found that the built-up area is not adequate or not as per the regulation. So therefore, they have confirmed the order. These order were challenged before this honorable court, and this honorable court will come to page 59. Lordship may directly come to page 61. Paragraph 4. On an appeal being carried by the petitioner before the appellate authorities of the NCT, the appellate order dated 11/3/2020 was passed. As per the appellate order, the earlier reason of withdrawing the recognition on the ground of approval faculty list as per NCT regulation 14 being not available was found to be unacceptable. But at the same time, the withdrawal was retained for another reason, that is institute lacked the required built up area. In these circumstances, we have to understand that where on one hand, the notice were issued for another reason for withdrawing the recognition, but ultimately the appellate authority has accepted the reply given against the such order, but had retained the withdrawal of another reason for which no notice was issued. So and so for the NCTE dispute the same and submit just some kind of notice was issued, but submission remained not very clear, and no so-called notice issued by the NCTE pertaining to built-up area was brought to the notice of the court. In the resultant situation, if the authorities under the NCTE are of the view that recognition of the petitioner institute is unsustainable because of any such other reason, the NCTE would be at liberty to issue appropriate notices to the petitioner institute, and after getting their reply may pass reason order as may be permissible under the law. Till such an exercise is undertaken, the impugn order withdrawing the recognition of the petitioner institute dated 26/8/2019 shall be kept in abeyance. So accordingly, recognition was revived, but pursuant to the direction of this court, my lord, at page 63, they have issued a notice. The next page. Now, lordship may come to the next page, my lord, directly, my lord, page 64. And whereas the institution has submitted representation dated 17/8/2020 and 26/11/20 received on 14/9/20 and 7/12/2020 respectively, the ERC in its meeting dated so held on 3rd March 21 considered the representation of the institute along with other dated 17/2/2021 passed by the Honorable High Court of Guwahati in WPC number so. The original file and other related documents in light of the NCTE Act 1993 NCTE regulation guideline issued by the NCTE from time to time decided as under. The institution is not submitted latest faculty list duly approved by the concerned affiliating body and any supporting documents, but only submitted two representation dated so wherein mentioned that 3 part-time teachers have been appointed as full-time teacher, which is not acceptable. Malad, here again, you for a Malad clarification, Malad, the so-called initial so-called notice was, Malad, that the faculty list was not available. Appellate authority found that the faculty list is available, but the built-up area is not there. Then, Malad, this High Court said that this particular reason was not cited in this so-called notice. So, if you issue appropriate so-called notice and take action till then, the order of withdrawal of the recognition was kept in abeyance. Now, this time again, they have gone back to the earlier, which was appellate authority has confirmed that the faculty list is available. They have cited the same reason. Against that, my lord, pursuant to this, my lord, I have given the explanation to them that this factor has already been considered by the appellate authority and found this particular ground is all right, my lord. But they did not, my lord, accept, and then final notice has been issued. Your lordship will find the final notice, my lord, at page, my lord, 66. This final so-called notice reiterating, my lord, the same ground, and thereafter, my lord, will find the impugn order has been issued. Page 73. Let's may come to page 70. Six, my lord. Clause B, my lord. Third line. On further verification of copy of all faculty list, session 2018-19 dated so-and-so, submitting along with letter dated so in response to so-called notice dated so-and-so, before withdrawal of the order dated so-and-so, and the present faculty list so-and-so, following discrepancies have been observed. So, my lord, date of joining in respect of principal shown in all approved faculty list as so-and-so, which does not match with the date of joining shown in the present list. So this 1, 2, 3 ground, that is mismatch with the date of the earlier document and the present document. This was not a so-called which was given to me, and the remaining that 2 lecturers do not possess the qualification. These were also not the original on which the so-called notice was issued. So this was again appeal against, but then they did not pass any order. So I have approached this honorable court, and your lordship was please to consider the matter, at page 80. relevant, my lord, page 81. Mr. I. Alam, Learned Sending Council, NCTE has produced a communication dated 27/7/22 from the authorities of the NCTE, which indicates that as mandated by the MHRD notification dated demand, the authority of the NCTE are yet to receive hard copy of the appeal filed by the petitioner under section 18 of the National Council for Teachers Education Act. In that view of the matter, the petitioner is directed to furnish a hard copy of the appeal to the authority of the NCTE within a period of 10 days from today. On receipt of the hard copy of the appeal to be submitted by the petitioner, the NCTE shall consider the dispose of the appeal at the earliest. Till the appeal is considered by the authorities of the NCTE, the order dated 31/1/2022 shall not be given effect to.
Where is this 31/1/2022? 31. Where is this order? 31/1/2022.
Page 73, my lord. 31/1/22, my lord.
Yes, yes.
The ground of rejection, my lord, is date of joining in respect of principal so and so, my lord, and proof. But these were not cited in the, my lord, so cause notice. They are the fresh grounds they have taken, my lord. Against that, my lord, I have preferred the appeal by online. I have the acknowledgement, everything was produced, my lord, but then they said that the hard copy was not received. So this honorable court was pleased to, my lord, direct to furnish the hard copy and to decide the matter. Now, my lord, after receipt of the hard copy, my lord, page 83, that is the impugned order, my lord, the appellate authority has passed. Your lordship will find that, my lord, page 84, noting the second last paragraph, noting the submission and oral argument advanced during the hearing by the appellant institution on 2/9/22. Observed that the institution submitted faculty list is not as per NCTE norms, still shortage of one qualified teacher. It is also observed that principal appointed by the institution is also not qualified as per NCTE norms. The appeal committee noted that ERC was justified in withdrawing recognition of the appellant institution on the grounds of the aforesaid deficiency, as the appellant institution has failed to rectify the deficiency. But again, what was there in the original order, they forgot that, my lord, and rather they said that the one qualified teachers are not there. Whereas on the above, your lordship will find they pointed out 2, and we have appointed 3. Page 84, just above the line, my lord, noting these are the, my lord, persons who have been appointed. One qualified teacher is not there. Which one is not there is not mentioned. It is also observed that principal appointed by the institution is also not qualified as per the NCTE norm. This was also not, my lord, shown, my lord, in the so cause notice, my lord. This, my lord, principal has been functioning since the inception, and, my lord, challenging this, my lord, I have, my lord, preferred this writ petition, but in the meantime, my lord, all along, my lord, they are showing one cause in the so cause notice, then original order is passed in another ground, then appellate authority, my lord, is passing, my lord, affirming the order on a different ground. All these days, my lord, they are just harassing me. So what, my lord, the petitioner thought, my lord, whatever they are saying, my lord, to comply with that, my lord. Accordingly, my lord, the principal has been removed, a fresh principal with the, my lord, educate qualification has been appointed. Then, my lord, not only they are saying one qualified teacher, we appointed, my lord, 3 qualified teachers, and we submitted a representation. Thought, my lord, the good sense will prevail, my lord, they will consider all these things and pass an order. They did not do so. Hence, my lord, I have approached this honorable court, my lord. Now, my lord, in an instruction, they have said, my lord, that representation that was submitted, whereby the new principal has been appointed with required qualification, etc., that has been rejected on the ground that after the appellate exercise of the appellate power by the authority under the NCTE Act, there is no other provision on which, my lord, the representation can be considered. So that is the ground, my lord, which they have rejected. Now, my lord, my whole challenge is the order dated 13/9/2022. Lordship has seen, my lord, that the so cause notice contains different deficiency. original order contains different deficiency and the appellate authority will concerns the different the deficiency. Now, so far as Act is concerned, section 13 of the NCTE Act, it's clearly provides NCTE Act 1993.
This is
93 Act I have already provided.
And in the section 13, NCTE Act 1913. For the purpose of ascertaining whether the recognized institutions are functioning in accordance with the provisions of this Act, the council may cause inspection of any such institute to be made by such person as it may direct in such manner as may be prescribed. The council shall communicate to the institution date on which inspection under subsection 1 is to be made, and the institution shall be entitled to be associated with the inspection in such manner as may be prescribed. The council shall communicate to the said institution its view in regard to the result of any such inspection, and may, after assigning the opinion of that institution, recommend to that institution the action to be taken as a result of such inspection. All communication to the institution under this section shall be made to the executive authority thereof, and the executive authority of the institution shall report to the council the action, if any, which is proposed to be taken for the purpose of implementing any such recommendation as is referred to subsection 3. Well, this section clearly provides you inspect. If you find any deficiency, you recommend what measures to be taken to the institute. Then the institute will report to you that these measures we have taken, and then you proceed. If it is not complied, then you can take the recourse to section 17 or whatever for withdrawing of the recognition. Now here, no such things have been done, no inspection has been done. Only on the basis of the documents I have submitted, they are finding one fault here. Then, as I have already narrated, now the institution is suffering. A fleet of teachers are there, students are there, and all along the teachers in this court has been protecting me because of the attitude of the respondent authority in how they are harassing me. At this stage, I paid this order dated 13/9/2022. Maybe state, and matter be heard. 22. Page 83, order dated 13/9/22. They have filed an affidavit. Nowhere they have mentioned that the ground on which the appellate authority has affirmed the order, any so-called notice has been issued. Nowhere they have said that the order, the original order, which was passed, it was preceded with an so-called notice on the ground. While similar action has been depicted by this honorable court and kept the order in abeyance. This is the order that may be state.
even if I stay this order, the other order stands.
Well, original order has been affirmed by the appellate order. So the appellate order, when it is state, the original order has merged with the appellate order. Appellate order, if it is state, that will continue. And in fact, that's what had been done in the earlier occasion. This court, your lordship also.
You filed your affidavit?
Yes,
Yes, they
it
have.
is on the record. On 29/5/2023,
Then we can go for a hearing of this matter. We can hear this matter.
Yes, my lord. On Thursday, my lord, I have no problem. I am ready.
I have, that's what, they have, even in the affidavit, they have not said that they have this particular action of the appellate authority or the original authority is preceded by a so-called notice on the ground on which these orders were passed. Nowhere they have said. That a paragraph 26 I have clearly mentioned that has not been replied to at all.
My lord, under section 17, my lord, at this stage, there your lordship may kindly peruse. That is clear, my lord, contravention of provision. Contravention of provision of the Act and consequences thereof. Where the regional committee is on its own motion or any representation received from any person satisfied that a recognized institution has contravened any of the provisions of this Act, or the rules, regulations, order made or issued thereunder, or any condition subject to which recognition under subsection 3 of section 14 or permission under subsection 3 of section 15 was granted, it may withdraw recognition such recognized institution for reasons to be recorded in writing. provided that no such order against the recognization shall be passed unless reasonable opportunity of making representation against the against the institution proposed order has been given to such recognized institution, provided further that the order withdrawing or refusing recognition passed by the regional committee shall come into force only with effect from the end of the academic session next following to the date of communication of such order. We have already 4 shockers notices have been served, my lord, but they failed to comply with the regulations of 2014. Thereafter, my lord, subsection 2, my lord,
We will hear the case. You want it on a hearing day or on motion day?
it will be better, my lord, in the hearing day, my lord. It takes some time.
I am on my lord, why I am praying for the my lord, stay, my lord, because the whatever deficiency they have shown in the appellate order, those I have already my lord rectified. I have given the documents. These are with them, my lord. In the meantime, my lord, if your lordship my lord intend to stay the order, my lord, in the meantime they may consider my those my lord documents and pass an order. Orders since your lordship will hear the matter, my lord. In 13, my lord.
But Mr. P.J. Saikel, senior counsel, assisted by Mr. A.K. Gupta. Gupta. Yes. General counsel for. Also heard Mr. Ayala, standing counsel, NCTE. Stop. Meetings are complete. Issue rule. Yes, all parties are represented.
Yes, my lord. Education is there, my lord. They are formal parties. They are there.
Yes, all parties are represented. No formal steps are required. Considering the urgency involved in the matter, this case for hearing on, when do you want? 13
My lord, if
or 15?
if not, my lord, if it convenient on 9/6/2009/6.
9.
My lord, can it be on 8
or 8 or 13, my lord, 13/6.
13/6 will be
13/6. 13/6.
13/6, 2022. Stop. In the interim. The impugned order. Dated 39/2022, isn't it?
That's
Shall remain suspended
My lord,
till the next written approval.
they will not admit any student, my lord. Otherwise, it will contravene on the section 17. Your lordship may kindly peruse the section.
my lord, this lordship is hearing on
If
13.
your lordship, they will admit,
University has just, my lord,
it will
issued
not
their
be recognized
notice.
by God.
They are to, my lord,
It is also made clear that the petitioners shall not admit any students till the next.
Yes.
Section 17.
may be permitted to upgrade the matter on that day if required. If an observation, my lord.
You can mention it. I'll keep it in mind.
Objection.
30.
Mayor, please, Lordship. Lordship, it is a compassionate appointment. On the last occasion, issue notice, Lordship.
Yes. Yes, Bukale.
My lord. In this matter, admittedly petitioner was minor, my lord. He was 14 years old at the time of making application.
But 14.
As such, his application was rejected by the DLC. And petitioner has stated in this application that 4 persons, similarly situated person, were also accommodated. But she is claiming negative equality, my lord. Because admittedly,
One thing is negative equality is also there.
my lord, there,
On the other side also, you're also doing some wrongs, isn't it?
that is my lord department. If required, my lord, we will file affidavit in this matter, my lord.
File it within 1 week.
The notice not yet issued, my lord. The notice,
Notice is issued.
notice issued.
Your good name, please.
P. Ghosh, Lordship.
Big ghost. Okay, Bukale, then governor advocate is Allah. How much time?
3 weeks, my lord.
Not 3 weeks.
My lord is from Barpeta.
Well, 3 weeks time. To file contract.
Extra copy maybe.
Yes, after 3 weeks. Finish extra copy.
16 and 17.
May I please your lordship? My lord, I'm sorry, that time I was in another court on lag, not appeared.
Yes.
So lordships, this case is relating to provincialization service of the petitioner. It is a high school, Taranepur High School, which was established in 1959 and recognized in the year 1992. Petitioner was appointed as second LD assistant, lower division assistant, on 28 to 1996. Accordingly, she joined on 1/3/1996. The appointment letter is page 25. That time school was venture. Now it has been provincialized in terms of the 2011 Act. Page 25, lordships. My appointment letter.
Yes, then.
I joined on 1/3/1996, that is page 26. I was appointed as second lower division assistant, and accordingly my appointment has been approved by the inspector of schools, that is page 27. Approval 31/3/1997. That one employee, Mr. Jalaluddin, was appointed as first lower division assistant. He died on 26/12/2007. And after his death, private respondent number 8 has been appointed, who was appointed on 4/2/2008. Naturally, she is junior to me. And at the time of appointment, private respondent 8 was not eligible. She is underqualified as well as beyond age. Age is required to be 18 to 36 years. That time she was more than 36 years. So not even eligible. What happened after 2011 Act, Assam Venture Education Institution came into force in 2011, authority decided to publish a service of the employees of the venture education institutions. My name had been forwarded and the petitioner's respondent 8 name also been forwarded. That is page 28. Page 28, you will find that form forwarded for provincialization of the employees by the headmaster. Page 30, lordships will find bottom, last but one, page 30. Junior assistant, Udeza Begum. She is private respondent number 8. Lordship age mentioned 47 years, 5 months. Date, next column, but in the next column, date of joining, 4/2/2008. That shall be taken note, lordship. Date of joining is important. Junior, private junior. She is HSLC pass. Here is the person. Her name forwarded for provincialization in place of me. But another form, you're lost. My name forwarded another form that is beyond the post, because there's a minimum and maximum post to be provincialized. The minimum post to be maximum to be not. And my name forwarded in the next place, page 32. Your lordship will find page 32. Last but two, lordship, classical teacher, language teacher for non-Assamese medium schools. Left side, lordship will find page 32. Bottom, last but two, lordships. Saleha Begum Lashkar is the petitioner. Next, my age mentioned. Junior assistant second. Date of joining 1/3/96. I protested in this regard. But since I am senior to her, my service may provincialize. In spite of my protest, the provincialized service is the response number 8. Provincialized order is at page 35, lordships. Page 35. That is order dated 20th August 2013. Second column of the teacher's name, lordship. First column, the second column, serial number 9. Udeza Begum, junior assistant, date of joining,
It's 35.
page 35, provincialization order. Date of joining is very much important. Here is the Udeza Begum, serial number 9.
Is our respondent 8.
Respondent 8. I challenged it by filing a writ petition being WPC number that was next item lordship, that is 1651. Next writ petition. This our court issued notice of motion, issued notice to other side, and made an observation. The service of respondent 8 will be provincial subject to outcome of this orders. There, on receipt of notice, private respondent file joined their affidavit. That is, joint headmaster, secretary, as well as private respondent, joint affidavit has been filed. In the affidavit, they stated that my service has been terminated in the year 1999. That's why my service not been provincialized. Here is the case, my name forwarded in the format also, would come with different person stating that my service is terminated years in the year 1999. I do not have any knowledge, never served. It was afterthought and all manufactured document. This came with a personal lordship and a letter stating that in the year 1999, respondent 9 has been appointed on honorary basis because my service had been terminated. Then after the death of the husband of the Jalaluddin, respondent 8 is the wife of the Jalaluddin, she died 2007. And after his death, her appointment was regularly made. That is totally in violation of the procedure and rule lordship. Here, lordship will find my termination letter after receipt, page 43.
Yes.
Page 43. These are all manufactured afterthought because of receipt of the notice of
State has filed counter.
State has not filed any affidavit.
You'll have to file counters. So many allegations
My
against
lord,
you.
in this matter, there is no merit at all, my lord. My lord, kindly come to the prayer portion, page 19, my lord.
My submission remains also.
No, I'll hear you. I'm just.
Under the circumstances, writ petition 2428 of 2016, my lord. Under the circumstances, it is prayed that your lordship may be pleased to admit this petition, call for records, issue rule calling upon the respondents to show cause as to why a writ in the nature of certiorari shall not be issued, setting aside quashing impugn order dated 28 2013, resolution dated 31/10/1919, termination letter dated 31/12/1999, and resolution dated 31/12/1999. Inordinate delay, my lord. And the appointment letter dated 31/12/1999 of respondent number 8. And or as to why the writ of mandamus shall not be issued, commanding the respondent authority to cancel, withdraw, and or forbear from giving effect to impugn order dated 28 2013, resolution dated 31/10/1999, and termination letter dated 31/12/1999, and resolution dated 31/12/1999. And she seeking here provincialization under the Act of
Assam Venture Educational Institution Provincialization of Services Act 2011 as amended, which is struck down. And in our
I
High Court
approach
of
prior to
Division Bench,
2015.
a judgment is delivered, my lord, here 23/7/2018. So in paragraph, it is stated that the aforesaid state of confusion makes it indeterminable on the basis of the present materials being produced as to who between the appellant and respondent number 8 is senior. A further fact to be taken note of is that by the judgment and order dated 23/9/2016 in WPC number 3190/2012, the Assam Venture Educational Institution Provincialization of Services Act 2011 has been declared to be ultra vires. In view of the aspect that writ of mandamus is also been sought for as regards who between the appellant and the respondent number 8 is to be provincialized, which apparently would be a mandamus for provincialization under the Act of 2011, and as the Act of 2011 has been declared ultra vires, therefore no such mandamus can be issued under the present situation. It is also taken note of that upon the Act of 2011 being declared ultra vires, the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017 has been enacted, and under Section 24 of the Act 2017, the authorities in the Education Department are empowered to review any particular case where the provincialization had earlier been made under the Act of 2011 in an incorrect manner. This is the judgment that I have.
In the Eastern case filed prior to struck down of this act, and
Struck down.
even in the case, lordship, the found illegal, that has to be reviewed. Here is the illegal has been done.
But you have to, why don't you clarify your position? Apart from taking this preliminary grounds.
My lord, she was absent, my lord. She was absent, so she was terminated, my lord. And thereafter, she did
There are
not
some
come.
allegations saying that these are all manufactured documents, correct?
Yes, manufactured. Everything is after
Why didn't
filing
you
this.
clarify, why didn't you clarify this?
My lord, I have record with me, my lord. Yes, ma'am.
In this case, the earlier.
Whether
honorable court
they have
was-
served the
court
notice
was
to me,
record.
whether any so called issued in this
And
respect, that will be
government
looked at.
has produced the record, but has called the record that it is, you will place it, man.
Records were called for.
Yes.
Record of the school manual. Last
Original
night was
record
just the
wanted,
Beginning
please.
of the latest stage manual.
Okay.
Whether the petitioner was there, whether she was once appointed in the year 1997.
Okay.
And thereafter she did not
If
continue.
records are there, then we'll take up on a hearing date.
Yes.
Heard
But
April Barbour
original records required. This one wanted to see the original records.
Also heard Mr. You also
You,
heard
Sharma,
you, Sharma, then.
for secondary education department.
Starting council, secondary education. As well as.
Myself for respondent number 8, private respondent 8, man.
Raj Barb,
Yes,
Raj Barbour,
I'm
Senate
Raj
Council for Respondent. Is this matter? Or. 15th June. 15th of June will have.
15th of June. Lordship.
No.
58 of supplementary list
Obliged.
admissions.
May I please? My lord, in this case, my lord, some development has been taken place, my lord. I have forwarded one communication, my lord. So I have to take instruction. As per last order, my lord, we have to take instruction. by-
1 minute.
My lord, this is regarding, my lord, regularization, my lord, of assistant professor, my lord. Government has taken a decision, my lord. So, my lord, some process is going on, my lord. File is in the government office, my lord. Our name is, my lord, CL number 88, 81 and 82, my lord. Last page, my lord. Not yet finalized, my lord. 81 and 82, both the petition.
So you want some time?
Yes, my lord, I have some time, my lord, so. Minimum.
Mr. Digo,
Digo.
Google and counsel for petitioner. Place for how much time?
Minimum 3 weeks, my lord.
Place for 2 weeks time to receive instructions. Very good.
Highly
Please,
obliged.
59 and 60.
May I please, your lordship? Lordship, the matter here pertains to a seniority dispute between the petitioner and the private respondent. Lordship, here we have challenged one impugn order.
Notices are served on the.
Lordship, Lordship, pleadings are complete here, Lordship. In fact, the respondents have also filed their affidavit.
Okay.
Sir, reply. May I start, Lordship?
Yes.
My lord, in a hearing, NCT is required, my lord, here.
NCT, who are there?
I alum is appearing in the matter. He's here, Lordship.
You're ready? Parties are ready? Yes.
My lord, NCT is required because
NCT
they have B.Ed, actually challenge is B.Ed degree, my lord. And B.Ed degree, whether NCT is recognized or not. So they have to clarify whether.
The NCT, they have filed their affidavit.
They have already
their
filed their affidavit.
Where's Alam?
Lordship, the impugn order is at page 37.
But if Alam is not there, then there's
Lordship.
no point in taking it out. It's a question of B.Ed degrees.
Lordship, the B.Ed degree obtained by the petitioner is stated to be invalid, Lordship, because the college institution had not
Been recognized.
recognized. That is the ground. But if they had applied, if a college applies for recognition, then during that period, a degree is deemed to be valid. And this stand has been clarified by NCTE, affirming that the degree obtained by me is valid.
Okay.
They have stated in their affidavits. Lordship may take it after some time. I'll call him in the meantime.
Okay.
After some time. Lordship.
Twenty-three of Delhi Lane.
Lordship, matter may be disposed of with the direction of to file the representation before the district commissioner and secretary to the department of the secondary education, Lordship,
What is this matter?
regarding provincialization of their service, Lordship.
Huh?
Service of the provincialization of the service of the petitioner, Lordship. The petitioner was appointed on 20 23rd July 1990, Lordship. And his school was provincialized on 28 2013, Lordship. But the another person filed a writ petition before this honorable court. Due to pendency of that writ petition, the service of the petitioner was not provincialized on that
Where is
time.
that order?
Order is Lordship, page number 19.
You find the writ petition, isn't it?
On that time, the another person, one Kamrul Islam, he is appointed as a Assamese language teacher, and
You are the petitioner. You are the petitioner.
I am the petitioner.
Yes.
Yes, Lordship.
In that writ petition
Yes,
also.
Lordship.
Then
Then have a look the order dated, Lordship, page number 19, Lordship.
I'm on 19.
Directing the director of the secondary education Assam to cause verification of the matter through the appointed committees, that is district scrutiny committee, district level scrutiny committee and state level scrutiny committee, depending upon the outcome of the verification, future course of action in the matter will follow.
In the first writ petition, you want provincialization as Manipuri language teacher.
Yes, Lordship.
In the present writ petition, you want provincialization as Assamese language teacher.
First writ petition filed another person who is a Assamese language teacher, and I am the Manipuri language teacher. But in that school, there is no student of Assamese students, and is not continuously going on Assamese. So that's why, and I am still now doing work on that school, Lordship. After that, I filed a representation before the Director Secondary Education, Assam, Lordship.
Yes. Sham.
Then after forwarding letter, Lordship, the page number 22, Lordship.
Let him file a representation. Praying for regularization. Before whom it should make?
Before director.
That's what you want, isn't it?
In the year 2021, Lordship, other person service was provincialized, but due to some problem, my service was not provincialized. So my humble submission is that, Lordship, kindly consider my claim and similar order, dear Lordship. In this order, Lordship.
And I may be allowed to take instruction matter in this matter.
Why?
Earlier,
Instruction is referred matter.
You have not. 2021 matter, till now you have not received any instructions.
As a last chance.
para 4, Lordship. Similar kind of matter, Lordship.
We can dispose it of,
Yeah,
Mr. Chairman.
24 আপনি check করে দিন। Section 24 Section 14
14.
Section 14
Section 14 will not come into play. No orders has been passed. Either by the DLSC or the state level committee. DLC and the SLC, they have not passed any orders.
Yes.
She's just praying, he or she is just praying for the provincialization of the service. They have to make a representation.
Yes, ma'am.
Before whom? Secretary or the director?
Director.
Hurt MS,
A Begum Lot.
Beckham Leonard Council for the Petitioner. Also heard Mr. U Sharma. Leonard Standing Council Secretary,
Secondary Education Department.
Education Department for respondents 1, 2, 3,
Or I am appearing. Worship for respondent number
5,
2.
6, 5 and 6.
Worship for 2, 8.
Oh, 1,
I am 1, 3,
1,
5,
3,
and 6.
1, 3, 5 and 6. Mr. H. Alial, Leonard Standing Council Finance for respondent number 2.
I am for
And
respondent.
Mr. S. R. Barra, Leonard Government Advocate for respondent number 4. Stop. Para. The petitioner is a graduate and was appointed as a Manipuri language teacher at Mantishwar Ali Majumdar High School, Al Kapur, Kacha. Where's your appointment order? By order dated 23/7/1990, issued by the secretary. Is it secretary?
Secretary of Headmaster / Secretary of Manteshwar Ali Majumdar High
But
School.
there's no headmaster written here. By the secretary, Mandishwa Ali Majumdar High School, Al Kapur. Stop. Para. By this writ petition, petition is praying for a direction to the respondents to provincialize the service of the petitioner as what?
As Manipuri language teacher.
Manipuri language teacher. Stop. Para. No counter affidavit has to file by the state respondents. And considering the limited prayer involved, this court is of the considered opinion that it would be in the hands of justice to dispose of the present writ petition instead of present writ petition at this stage. So, but according to common, petitioner is directed to file a representation.
Along with my lord, copy of writ petition and my lord annex
To whom?
to director.
Before the director. Secondary Education Department,
Secondary Education.
Assam. Public respondent number 3. By annexing a copy of the present petition. along with all the annexes appended by it. Within a period of,
1 month,
you want 1 month to make your representation
15 days.
within a period of 15 days from today.
2 months.
Thereafter, from the respondent number 2 on receipt of the representation shall consider the same and dispose of the, shall consider and dispose of the same
DLC to recommend.
within the
for
period of 1 month
DLC
from
to
the date of
recommend.
receipt of the representation.
DLC to recommend for.
Stop.
DLC to recommend for. 9 days. My lord, DLC's recommendation is also required, my lord.
That is why I'm saying DLC recommendation is required, SLC recommendation.
Yes,
is required.
This
First DLC, thereafter, my
There
lord,
has been no consideration.
DLC is deputy commissioner, my lord.
Let the direct, let him file a representation before director. Director will remand the matter down.
Yes.
With the application, director.
deeply operated.
59 and 60.
May I please your lordship, the council.
My lord, we have filed our affidavit, counter affidavit, my lord.
Yes.
The para 4 and 7, my lord, we have stated.
Are you ready for the matter? Charma?
Yes.
You're ready?
Yes.
Yes.
Lordship, the matter here pertains to the seniority dispute between the petitioner and the private respondent number 4, Lordship.
Who appears for private respondent 4?
Lordship, he was absent on the last occasion also.
Who's respondent number 4? Notice has been served.
Lordship. He has in fact filed his affidavit also, Lordship.
So who appears for respondent 4? A Deka.
A Deka appeared on earlier occasion, Lordship. After that, someone else appeared. Different, they have engaged different counsel to respond number 4. But
Where's
he's not
Deka?
present.
Please, we can hear from him something. Okay. Your good name, please.
Lordship, A Talukdar, Lordship. Miss A Taluk.
Heard MS A Talukdar, and counsel for the petitioner. Also heard Mr. U Sharma, and the standing counsel. Secondary Education, I alum, and the standing counsel. NCTE. Stop. None appears for the respond number 4. Stop. List the matter again after. 2
Lordship, may
weeks.
kindly fix the date, Lordship. Short date.
List the matter again of. No, I'll just say 2 weeks. If the respondent number 4 is not represented on the next returnable date, this case shall proceed ex parte against respondent.
Lordship, after a week, Lordship. Short.
2 weeks, make it 2 weeks. Let him come.
Much obliged, Lordship.
Order.
Please, Your Lordship.
Mm.
Your Lordship, the contempt petition is for non-compliance of the order, judgment and order dated 4/11/2016.
Page.
The order starts at page 10, Your Lordship. The operative part of the order is, Your Lordship would kindly come to page 14.
Mm.
The second last paragraph, Your Lordship. In view of the above, respond number 1 and 2 are directed to take steps for regularization of the service of the petitioner as Assamese language teacher either in Margaretta Town High School or in any other school in the district of Tinsukia within a period of 8 weeks. Now, in the pendency of this matter, your lordship, the functionaries of respondent number 1 and 2, on quite a few occasions, they demitted their office. The last I that you had filed, your lordship, was to bring on record the new incumbents of respondent number 1 and 2, secretary for the finance department and the secondary department. Today, I just got to know that the secretary of the secondary education has also further changed. This has happened numerous times, your lordship. In fact, if your lordship sees, we are on to respondent number 7 and 8 now. Whereas the order was initially against contempt number 1 and 2. If your
Whatever
lordship-
it is now, you have to file an.
I have to
improvement
do that, your lordship. I have to do that to take these steps again. Prefer a notice and then thereafter impede them by way of an IA. Well, so as of now, your lordship will not go into the details of the matter since
Okay. Mr.
M. Sharma, your lordship.
M. Sharma, learned counsel for the petitioner, submits that he requires, how much time he requires?
We'll prefer the notice tomorrow. Thereafter, within 15 days, we'll file an IA. The IA will be recorded as a separate matter before your lordship. So your lordship will not fix a date. Yes, yes, yes.
Press for 2 weeks time
Yes.
to file an appropriate application.
Yes.
Going for implementation of necessary parties. Press on not list after 2 weeks.
I'm grateful, lordship.
32.
32 lawsuits here, we need some time because we have filed an SLP before the Supreme Court lawsuit that has already been filed, and because of the summer vacation that is not been listed. So let it come up in the month of lawsuit, I think July lawsuit. Let the matter be fixed. Lawsuit.
Lordship,
Against this judgment?
Yes, lawsuit. We have that has already been
Yes.
filed on lawsuits.
this order is of Lordship 2017.
2017 matter, you filed it this year.
No, we have filed an appeal. That appeal was dismissed, and we have approached the Supreme Court lawsuit against this. Against this order lawsuit, then appeal was filed. That was lawsuit rejected. Then against it, we have already filed an SLP on 3/5/2023 lawsuits. And because of answering summer vacation in the Supreme Court lawsuit, that has not yet been listed lawsuit.
Lordship may kindly peruse last order 3/5/23.
Yes. You prayed for adjournment to comply with the court order. Subject to whatever order is passed in the SLP.
Though I am not in this context, I am submitting on behalf of NJ Khatuniya lawsuit that he has requested that as the SLP is pending lawsuit, it has already been filed. So he has requested me to take some time.
Okay. Your good name, please.
Pardon, Lordship,
Your good name.
as Dev.
Her name is Dev, let me counsel for the petition. Mr. SMT Chishti,
On behalf of Mr. NJ Khatuniya,
standing counsel. No, no. Mr. SMT Chishti, counsel appearing on behalf of Mr. NG Katania. Submits that against the order dated 3/3/2017. Passed in WBC number 268 of 2015. The state respondents preferred an appeal, which was registered as WA 355 of 2022. The said appeal was also dismissed on 22/2023. So it is submitted that the state has preferred an SLP, against the order dated 2023. This has filed an SLP against the said orders and prays that the matter be deferred for some time. Stop. Prayers allowed. Please this matter.
Lordship,
Again,
last month of July, last week of July, Lordship, that will be better. Otherwise, there's summer vacation also going on in the Supreme Court. Lordship.
25th July.
Yeah.
25th.
Oblige. Hey.
$33.
Lordship, I need some time to file an IA to include the newly Secretary of Elementary Education. Lordship.
You're Mr.
R. Sharma, Lordship.
Mr. R. Sharma, then the council book. Place for how much time?
3 weeks, Lordship.
2 weeks time to file an appropriate application for involvement of necessary parties. Prayers allowed. List of the 3 weeks.
Deeply obliged.
34.
Yeah, please. Lordship. The direction of this honorable court, Lordship, is at base relevant is a 31. Lordship.
Last occasion, they were supposed to file impleading petition, Lordships, order dated 23/9/22, Lordship.
Have you filed your implement application?
Lorships. So we have communicated this order to the newly incumbent, but I is to be paid.
When you file your IA,
Well, next week,
Mr. M. Khan, learned counsel for the petition. Prayers for 1 week. One week time to file an appropriate application for one of necessary parties. Prayers allowed. Please after 1 week.
35.
may please. My lord, in this case, my lord, we have taken steps to all the respondent, my lord. And they have not filed affidavit till today, my lord. Affidavit
Notice
is
has been
required.
served.
Yes, my lord.
Notice, sir.
Notice, sir, my lord.
Lordship, I appear on behalf of respondent number 6, Lordship. Lordship, I was impleaded, Lordship, as respondent number 6, so we need some time to file our affidavit.
Yeah, Mr.
Eboro, my lord.
But Mr. Ebora.
Eboro.
Eboro, then counsel for the petition. Mr.
A. Ganguly.
A. Ganguly, then counsel appearing for respond number 6.
Yes, 6.
Praise for
10 days.
Praise for 2 weeks time to file out. Praise about this up to 2 weeks.
Obliged.
36.
36, Lordship, is a state review, Lordship. Here, Lordship, Mr. R. Modunda, he was appearing in this case. No, Lordship, he is out of station. He is in Delhi for some personal reason, Lordship. So may matter may taken up after 15th.
After
15th of.
My lord,
But
my-
entire record are with him, Lordship.
my lord, they took the adjournments by getting a stay order of the judgment passed by in 2015.
Lordship, fix it on
And
the
lordship,
16th.
they are taking the adjournments on decision of ground. Lordship, made the case may be kindly taken up day after tomorrow because they are the urgency. I am not getting the area salary.
1 minute, Psyche, 1 minute.
Judgment is at my lord, page number, my lord, page number 55.
When is he coming back?
Yes, he will be coming back on 13th, Lordship.
So let us fix it on
15 is a hearing day, Lordship.
Now, who is repairing? I did not appear for him.
Rajesh Modunda,
Isn't that? Huh?
Entire record.
R. Majumdar is appearing. He is in Delhi for some personal works.
My lord,
So let us.
15 is a hearing day, Lordship. Can you fix it on 15?
Yes.
Lordship, if he is ill, I do not know, illegal, hoping.
On request made on behalf of Mr. R. Maginder, learned counsel for the petition. List the matter on 15th.
Yes.
June.
Oblige.
37 lawsuits, we are issuing the speaking order soon, lawsuits. Lawsuit may kindly grant me 10 days time, lawsuits. I have already communicated lawsuit, the
My
speaking
lord,
order.
earlier
Decided-
so many times time has been granted to my lord. My lord, this is a 21 matter, my lord. There are the specific directions, my lord.
Ultimately, petitioner has no.
My lord,
legal
so many
right.
times has been granted.
They will be rejected, only the speaking order is to be issued, lawsuit.
When are you issuing the order?
Lawsuits, within 10 days, lawsuit. I have already communicated lawsuit. I have asked them to issue the speaking order, lawsuit.
When was the order passed?
My lord, order first, my lord, page number 9, my lord. Order pass 18/11/2019, my lord.
19.
My lord. Relevant portion, page number 12, my lord. Paragraph 6, my lord.
Yes, Chisti,
Yes, lawsuit.
what's taking you so long?
Lawsuit may kindly give me 1 week time, lawsuit. We have already decided the matter, lawsuit. Only the speaking order is to be issued, lawsuit. Otherwise he has no right to for confirmation.
Your good name, please.
R. Varma, my lord.
But our Barwal and the council.
And moreover, lawsuit, all the respondents are they have already been transferred, lawsuit. He has not anyway.
No,
lawsuit, we are
already
issuing-
two. There is two already implemented. There are
Request
present.
made by Assembly
present
Chisti,
item.
learned counsel for the respondent number.
1 and 2.
1 and 2, lawsuit.
One and
Both
two.
the respondents.
List the matter after 1 week.
Well, fix a date, my lord. Otherwise, matter.
16th June.
Deeply obliged.
May I please, your worship, let's say contempt matter, I take your lordship and attention on order dated 26th of August 2022.
Notice served,
My lord, your lordship order may kindly be placed, my lord.
page,
20, this honorable court order, my lord.
page.
Order sheet, my lord.
Oh, order.
My lord, 26th of August, my lord.
26th of August,
My lord.
2022.
2.
Yes, where's Kaushik?
Now, your lordship, 9/3, my lord, 2023. Next order, my lord. 9th of March 2023.
Yes, who appears?
Arrear salary, my lord, since 2015, my lord. It's a matter, my lord.
Who appears?
Sir, Mr. B. Kaushik.
P. Kaushik is there, P. Pora is there.
Yes, my lord. P. Bora is there. If your lordship may I pray, let the commissioner finance be given personal appearance, my lord. Everybody will come, my lord. And otherwise, they are not bothered to complain.
Matter may be taken any other time, my lord.
Why?
Because I am appearing on behalf of B. Kaushik. He's not available, my lord, now. Madam, have we taken
See,
any
this
other?
is a matter of career salary.
Madam.
Last occasion, you said that it has been put up, questions were asked, you have given your reply. And then recently you have said that now you have written to the finance department. So this court wanted an up-to-date status report.
Any other than madam? I will
And
inform
that
you.
salary, decade 2010 to 12.
But AK Hussain, level counsel for the petition. On request made on behalf of Mr. D. Kaushal. Standing counsel,
Yes, my lord.
Department of
Elementary,
Elementary Education. We'll list it day after tomorrow.
my lord.
It's the matter of ninth.
But 42 is the same arising at common judgment, my lord. 42 is also same, exactly the same.
But here the parties are same.
Same. my lord.
Here Chalia is there, T Nayak. is
Yes,
there.
my lord. Judgment is the same, arising at same judgment, my lord.
Wait for your turn.
My lord.
Forty-one.
Now it's getting quite cold.
May I please, your lordship? Kindly peruse the last order, your lordship, on 29/5/23, your lordship.
Yeah, here lawsuit, I have an instruction to take some more time lawsuit because the file has, department is willing, is preparing to send a file to the judicial for his view lawsuits. But here lawsuits, 4 weeks time they can be given lawsuits.
For the judicial department's view.
Yeah, lawsuit, here lawsuit matter is a little bit, lawsuits to give the relief to the 1% lawsuit. There are another 700 access cases are there. So lot of cases are lawsuits, so we have to take a decision in the whole lawsuits. So department is preparing to lawsuits is to send it to get a view from the judicial department. Thereafter lawsuit that will be taken care of. So 4 weeks time they can be given lawsuits.
A date will be
Matter
fixed,
is a
your
little
lordship.
bit complicated. Lawsuit.
Heard MS.
S. Nazir, your lordship. I'm appearing for Mr. K. M. Hassan, your lordship.
As noted, level counsel appearing on behalf of the CPM Hassan, level counsel for petitioner on request made by SNT Chishti, level counsel for respond number.
I'm on behalf of Mr. R. Majumdar as he author
Appearing on
special.
behalf of our Majinder, then counsel for the,
Responder one lawsuits.
for the respond number 1. List this matter again on
After 4 weeks lawsuit, we need some time lawsuit.
4 weeks will come after the summer vacation.
Yes, your lord.
A date will be
19th.
Yes, oblige your lord.
19th of July. Oblige, your lordship.
42.
42 is also same, my lord. Kindly page the order dated 9/3, my lord. Same order like 40, my lord.
Yes. Chalia.
Lordship, here the matter pertains to payment of area salary, my lords. Here on the last date also a statement was made that the proposal has been sent to the finance department. That is when, since we did not have a record, we asked for the communication through which the proposal was sent, my lords. So a statement was made by Mr. P.K. Bora, my lords. So he was appearing, I think, my lords. But he had not produced a communication through which they had sent it to the finance department. Because of which we have not been able, whether or not they have, it was on the basis of a statement, my lords, made.
Where's Bora?
No, my lord, that communication was placed before this, all it was supplied also to me also.
Reflected in the copy. That's why I think he has missed this item lawsuit. Only.
Perhaps it is in the record, that communication, I don't know, the P Bora on that day, my lord, in this code, my lord, give me a copy also, like item 40. This is a communication dated 6/3/2023. Whether it is in the file or record or not, my lord, it's a load sheet, my lord. Downloaded copy, my lord. Dated 6/3, it will not voice a copy.
is appearing for respondent
Lordship, I'm appearing for respondent number 2.
and P.K. Bora.
PK Vora appears for respondent number 1, Your Lordship.
Okay.
Sometime B Kaushik, sometime
But
Bora.
A.K. Hussain, then a counsel for the petitioner. Registry directed to reflect the name of Mr. P.K. Bora, then the counsel. Appearing for the respondent number 1
Respondent number 1, Lordship.
and list this matter after 1 week.
1 week,
weeks.
Lordship. Lordship, in 1 week, Lordship, I just need the communication through which they have sent the proposal, my Lordship. That will be, I think.
2 weeks.
May I pray, my lord? Like 40 and 42 are arising at common judgment. Let these two matter maybe come after a week, my lord, along with this matter. Because these are interrelated, arising of same judgment, my lord.
Along with WBC number,
No, my lord, contempt petition number
along with contempt case 64 of
39 of 2022.
39 or 24.
No, my lord, 39. Item 40, my lord.
Okay, 39 of 20.
Lordship, the name of PK Bora may be reflected in both the
That's
results.
Lordship, next week, my lord.
2 weeks.
My lord, then, my lord, your lordship, kindly fix the date, my lord. Otherwise, very difficult. I have to make mention.
21st.
Hello.
Yes.
Lordship, here is also non-compliance of this honorable court's order, my lord,
Lordship, I have been instructed
9/5/22.
within 15 days, we are issuing lordships, the speaking order lordship, because the secretary has directed the director to.
Why are you taking so long to pass a
No,
speaking
my
order?
lord, kindly peruse the order 16/5. My lord, man is 50.
And already an
6
appeal
years,
has
my
been
lord.
filed by the opposite party in this case, Lord, and appeal is pending before the honorable court, division bench lordship.
No
this
order,
case.
my lord, for delay condemnation. There is no order of the appeal, my lord. Only delaying the process, my lord. My lord, more than 1 year. My person is 56 years. In Bhansar, my lord, he has been serving since 1986, my lord. He's going to retire, my lord.
If
Nothing
the
will
appeal
get
goes
it.
against the petitioner lordship, then everything
lord.
will be lordship.
My lord, kindly peruse the order 16/5, my lord.
I've seen. What do you want?
I in 2 weeks time, lordship,
Why 2 weeks?
because his case has to be placed before the SLSC, lordship. SLSC, after getting the SLSC's
But
approval,
Mr.
lordship.
Yama Kandar and the counsel for the petitioner on request made by SMT Chisti, then the counsel. Then the standing counsel.
No, I'm lordship here on behalf of Mr. Anjay Khatonia, lordship. He's on behalf of Anjay Khatonia, standing counsel for content, sole respondent, lordship.
Last time also you were appearing, Mr.
My
Chisti.
Last time, yes, lordship. My name was, yes, lordship.
For respond number,
The sole respondent, lordship.
for the sole respondent, list the matter after 2 weeks.
My lord, the date may be fixed, my lord.
List the matter on. The second.
I am up.
44.
This I.
May I please your lordship, that
What is this I?
High Court judgment was to pay the
1
revised
minute.
scale, my lord.
Yes.
My lord, the High Court judgment was to pay the pension with revised scale, my lord. That already, my lord, Director of Elementary Education sent the proposal before the Secretary Education. That is, in the Secretary Education, it is pending, my lord, from 8 April 2003. And
Similar prayer, my lord, earlier, my lord, madam, will fix day after tomorrow. I'm appearing on behalf of because he has left on.
my lord, let it come day after tomorrow or next week, my lord, in the end, he will apprise what is the position of the file, my lord, because it is lying before the Secretary.
Hurt Mr.
C. Goswami.
T. Goswami, then the counsel for petitioner on request made on behalf of
Because
D. Kaushik, then the counsel for the.
elementary.
Contemner, sole respondent.
For the
Sole
sole
respondent, my lord.
list the matter again on. When do you want?
Any other day,
Ninth.
45.
Made please, Lordship. Kindly peruse the order dated laws in my order, Lordship.
In this case, my lord, very important, 5 my lord. Full statement is necessary to file an application of.
1 minute.
On the other, my lord, on the same, on the same. Subject matter, my lord, another petition is pending.
Lordship, as per laws in my order, Lordship, respondent number 4 and 7 is same. So respondent number 7, I may allow to stack of Lordship. And matter may be listed for the admission, Lordship. As per office note dated, Lordship, service is already completed, Lordship.
Respondent number
4 and 7,
are the same.
same, Lordship.
I'm appearing for respondent number 4. I'm appearing.
President and secretary, Lordship.
Mr.
R. Islam, Lordship, on behalf of Z. Hussain.
R. Islam, then counsel appearing on behalf of Z. Hussain. Praise for deletion of name of respondent number 7. On the ground that the respondent number 4 and respondent number 7 are the same. Are the same. Are same. Stop. The grace allowed. The name of respondent number 7 be deleted from the cost item. Stop. Mr. B.
Rahman.
Then a counsel for respondent number
5.
5. Praise for
4 weeks time to file. 4 weeks time.
4 weeks time to file contract. Praise allowed.
My name may be Lordship A. Sharma.
Mr. A. Sharma, the counsel appears for respondent number 4.
I'm for 1, 2, and 3.
And MS.
H Terang. H Terang.
You are
1,
the
2, 3.
standing counsel
Yes, my lord.
for
Secondary department, my lord.
7 appears for respondent 1.
Applies.
Apply.
47.
My lord, in this matter, we have received as instructions, my lord. We would like to file an affidavit, my lord.
Okay, just a minute.
Your lordship, kindly peruse the order dated 22/11/22. It's a long order, my last paragraph. The issue some extent related to my law point.
Any private respondents are here?
No, my lord. Because the impugn order was issued, my lord, as per my lord,
1 minute. Who are respondents 2 and 5?
my lord, they are not, my lord, just formal party, my lord, not the effective party, my lord. The effective party is respondent number 1 and 3. The impugn order issued by respondent number 3.
Okay, heard Mr. A.K. Hussain, then the counsel for the petitioner. MS
H Terang.
is Tarangpil and it's standing counsel. Secretary Education submits that she has received instructions and prays for
2 weeks, my lord.
2 weeks time to file contract. Prayers a lot. List the matter after 2 weeks in the admission column.
Hello.
48.
Dear please, your lordship, kindly see the order dated lordship 11/8/2002, page number 19. Relevant for lordship. Last para.
Yes, now you can start.
Lordship, order, High Court order dated lordship 11/8/2022. Page number 19, lordship.
Yeah,
Relevant for last,
Service is yet to be
last
completed.
para.
Notices issued on 22/23.
Who's the
And the Vijay Secretary, she is no longer the secretary and commissioner secretary because she is on long leave because of her illness lawsuits. And she is not in service, lordship. She is in long leave. She is suffering from a disease, lordship. Now she is on the long leave, lordship.
So who's in charge of?
And now
secretary?
Naranpur.
So you'll have to take
Yes,
steps.
lordship. Otherwise, lordship, if tendency of the.
You'll have to take steps.
Then my lord, we ready to take incumbent with complete party.
Have you served notice on the new
Yes,
incumbent?
no, my lord. Earlier it
Then-
was Vijay Chakraborty. Today I have come to know that, my lord.
So you'll have to serve notice. After that, you'll have to wait for some time. After that, only you can find.
Yes, yes.
When is it? Earlier occasion they took instruction, they took time, my lord. Now today they says incumbent.
Okay, Mr.
HL, my lord.
Hey, Charlie, then the council for
We ready to incumbent, my lord, party.
praise for 3 weeks time. I'll give you.
2 weeks we will answer, my lord.
Not 2 weeks. There are some formalities to be completed. Praise for 3 weeks time. To file an appropriate application, praying for improvement of necessary parties. Praise allowed, least up to 3 weeks.
49.
My lord, this is contempt matter, my lord, notice yet not issued, my lord, in this case.
Notice not issued. Why?
Because my lord, nowadays, my lord, the justice, my lord, listing the matter, my lord, contempt matter, my lord.
Where's the order?
Below the cause list, my lord.
Where's the
My lord,
order?
page 26, my lord.
13.5.
26, my lord, annexure 7 is the order, my lord. And relevant portion, my lord, page 28. Paragraph 5, my lord, last paragraph. My lord.
Thirteen five 2022. When did you file this contempt?
Yes, my lord. It was, my lord, the application submitted, my lord, page 30, my lord.
1 minute. When did you file this contempt petition?
Yes, my lord, it was filed, my lord. Yes, my lord. April, my lord, it was filed, my lord.
Okay.
Specific date.
Mr. M. Barwell and counsel for the petitioner. Issue notice. Petitioner takes steps for service of notice on the sole respondent by registered post AD within 1 week. List the matter after 6 weeks.
Obliged.
50.
Worship, in this case, notice is not issued, my lord. Our course order, page 15. Page 15. Direction, my lord, 17. Paragraph 5. And appeal has been filed, page 18. Accordingly, hearing also done.
Appeal?
Appeal, page 18, my lord, 10/11/2022. Page 18, in terms of our court's order, appeal under section 14 was filed. And then page 24, hearing was done on 27/3/2023. But till date, no speaking order, nothing has been passed. Yes, sir. Your lordship's direction, petitioner was directed to file an appeal seeking provincialization. Accordingly, appeal was filed. Hearing also completed of the private respondent and petitioner. Page 24. Hearing was done on 27/3/23 in the month of March. Respondent is supposed to pass a speaking order.
Okay, my conduct, let me consult for the petition. Issue notice. Petitioner to take steps for service of notice on the sole respondent by registered post AD within 1 week from today. List after 6 weeks.
I'm up.
51.
May I please, your lordship?
Uh,
Lordship, notice was not served.
Notice not served.
Not issued.
Where is the order?
Order, lordship, page 8, 11%10, lordship. To reconsider the interview, the matter required to reconsider in according to the directive table placed before the next DLC meeting. Page 10,
When did you file your
22/5/2013. 23,
when did you file this contempt petition?
22nd, lordship.
23rd May. Party Alamgir, learned counsel for the petition. Issue notice. Petitioner next steps for service of notice on the sole respondent by registered post AD within 1 week. From list after 6 weeks.
52.
May I please, your lordship?
Oh.
Contempt matter,
No notice.
yes, no notice.
Where's the order?
Order
8-2.
annexure A at page 11. Order dated 8/2/2023. By this order dated, Honorable Court directed the respondent number 2 to pass a speaking order and to dispose of the representation of the petitioner, which has not been done till date. And so it is nearly 3 months. Only 2 months was granted, but 3 months is nearly to be.
Your good name?
R.K. Das.
Heard Mr. Arkedas.
R.K. Das. R.K. Das.
Arkedas, the counsel for petition. Issue notice. Petitioner takes steps for service of notice on the sole respondent by registered post AD within 1 week. List the matter up to 6 weeks.
Applies to you.
53 and 54.
What is this IA?
May I please order? In this case, my lord, initially contempt petition was filed as 50 of 2021 against the Amarjyoti Burman, my lord, Secretary of Education Department, BTC. In their reply, my lord, so course, they have stated that they have taken steps, but since the appropriate authority is the Education Department, elementary, for payment of my salary, my lord. And so they wrote to the Education Department, it was kept pending. So in view of that stand taken by their respondents, my lord, we have no alternative but to make the Secretary Education Department as a party respondent, my lord, in this case, my lord. That's why I has been fined, actually, man. That in fact, this matter came up for Justice Pathak on 5/1/2023, my lord. And there their lordship that has that I have enclosed the order in this case, my page 8, my lord. In this case number IA 585, my lord.
Where's the order?
Order, your lord, paragraph 8, page 8, my lord. It starts from page 7, my lord.
1 minute.
On the prayer of so and so, list the matter of 3 weeks. In meanwhile, petitioner is allowed to file appropriate application for implement necessary party, my lord. Because you have taken up the main contempt case. In the main contempt case, the main contender, my lord, he has taken the stand, my lord, that he has wrote that your lordship will find when in the so-called reply filed by the respondent number 1, my lord, that he has returned to the Secretary Education Elementary Education Department, saying that the incumbent was earlier appointed by the before the bifurcation of the BTC, my lord, by the director.
So you want to implement the elementary education?
Yes,
department?
yes, ma'am. That is my
Was
question.
elementary education department a party in the writ petition?
In the writ petition, my lord, it was the department. In the original writ petition, let me check it, my lord. State of Assam is party, my lord, in the department by the Secretary to the Education Department. State of Assam is party.
State of Assam may be a party,
Yes.
elementary education
Yes.
department is
Yes.
the party or not?
Yes, Department of Elementary Education, Secretary, yes, number one, ma'am.
Is it the party?
Yes,
Then the contempt was filed against whom?
against the actually Secretary of Education, BTC Kokrajhar, ma'am. That direction was given to them, actually, to the Honorable Justice Singh, my lord, in the order that is under challenge, my lord. That is in the main contempt petition, my lord. That your lordship will find at page contempt number 50 of 2021, my lord.
Yes, Bora,
I filed my affidavit, madam. I filed my affidavit and
in
my,
the contempt.
yes, madam. Contempt.
No, in the IA,
I have no objection, madam.
anybody? No one. Who can?
Yes, yes.
I have no objection. madam.
You are Mr.
Mr. P. Kotogi, my lord.
Heard P. Kotaki and counsel for the applicant. Also had heard Mr. B. Bora, Leonard,
As well,
A.S. Bora, Leonard counsel.
sole respondent. I'm waiting for the sole respondent. Now, next will be the.
For the sole respondent, stop. By this application, the applicant is praying for impeachment of Shri Narayan Konwar, IAS. Secretary, Department Elementary, I don't think there's an elementary education,
It's now secondary school education.
it will be school education.
School education.
Secretary, School Education,
I will correct it.
Government of Assam. As party response number 2.
Now, they have not served any copy to the secretary lordship. They have not annexed any representation.
No, that is come later on, my lord.
That will come later on,
Because
on the ground that,
Yes.
what are the grounds?
because the stand taken by the respondent, my lord, respondent number one, my lord, that it is said that he has wrote letter to the secretary, commissioner to take appropriate decision over regulation of service. That
On the
paragraph,
ground that it is the Secretary School Education who shall take the appropriate decision while implementing the judgment passed by this court. Stop. Mr. S. Bora, the standing learned counsel for the sole respondent has no objections. On consideration of the submission made, this court, on consideration of the submission made, the prayer for impeachment is allowed. IS disposed, and in the contempt petition, in view of the order passed today in IA number 585 of 2023. Let Shri, what is it?
Narayan Kaur.
Shri Narayan Konwar, IS Secretary, School Education.
Secretary school education lordship.
Secretary School Education
Department of
Department,
School Education.
be implemented as party respondent number
two, my lord.
2 in the present contempt petition. Stop. Are you appearing now?
No, notice with full lordship.
Issue notice on the newly implemented respondent number 2. Petitioner to take steps for service of notice on the respondent number 2 by registered post AD within 1 week from today.
No, 2 days, we need 3 days, my lord.
1 week from today, list the matter after 6 weeks.
The WPC also has a come, my lord, that is. For that is main case, my lord, 403 of
Main case is
2007.
allowed time with available.
Hmm?
The main case is.
In that case, my lord, they have not filed affidavit as yet, my
I
lord.
cannot, madam.
That's why these matters will come out after 6 weeks.
Not-
Yes, yes.
55.
Well, here we have received a verbal instruction that the petition has already joined in his place of posting, but we are waiting for the written instruction lordship.
No, my lord,
I think on 10/5 we are joined.
but so my lord, I cannot be sidelined from the silence of this transfer order, my lord. Although he is joined, my lord, that order is illegal. By compulsion, he is joined, but he cannot be sidelined from the silence this order, my lord. Your lordship heard the matter.
Exactly.
That entire matter may be hard. my lord.
Then lordship, we have to take the whole instruction, yes. A new matter, 23 matters, lordship, let it come.
That matter may be coming admission of column, my lord. Service is completed, my lord.
Services.
Service has
Yes,
to be
my lord. There
completed.
is no private respondent, my lord, that was struck down by the honorable court, my lord. And first order is paragraph number 2 and 3, my lord.
You want to file counter affidavit?
Yes, lordship, we have to take instruction, lordship, the whole instruction, lordship, yes. And private respondent is also there.
Interim order is there, isn't there?
Yes, my lord. Interim order is there, my lord.
There?
Interim order.
Status quo, my lord.
Status quo, lordship.
Status quo.
He has already joined, lordship. status quo কেতিয়া দিছিলে?
When was status quo passed? 3/5/2023.
Yes, my lord. After the status quo order, my lord.
You went and joined.
Yes, join after some problems, my lord, but they still the petitioner
Let it
is,
come after vacation
After
lordship.
status quo order was passed, you went and joined.
my lord. Status quo order, before status quo order, he has joined. my lord. Problem is there, my lord. There is verbal, my lord. He was on leave, and
Okay, heard Mr. R. Islam.
Islam, my lord.
Then the counsel for the petitioner. Okay. Mr. SMD still understanding counsel,
1, 2,
which
4, 5.
department? Elementary education
Yes,
department.
1, 2, 4, 5.
Appearing for respondents, 1, 2, 4, and 5, praise for.
4 weeks time, let it come after vacation lordship.
Oh,
Yes, he has
that
already
is
joined
our
his.
contract. Praise the Lord. Please, the
Harassment, bro. Obliged.